Well, welcome, welcome, welcome. I am Tigress Sydney Acute McDaniel, the host and facilitator of the one, the only Evolve Weekly, the Ethical Gatekeeper. And I am here for multiple reasons today. Please give me grace. I am recovering from a pretty nasty little viral infection. It is not COVID, but I tell you, the way it's beating me down, it might as well be. Some of you know that I have allergic asthma. And so, of course, that puts me in a vulnerable spot for respiratory infections during the season. And it came from my jugular. So I've got my water here. I'm hopeful that I can hold back any coughing or anything like that. I am starting to feel better, but I am definitely not 100%. Okay, that out of the way, I'm believing that you are well. I'm sending positive energy to you. I know that other individuals, a lot of us are experiencing flu or respiratory viral infections or bronchitis or the like. And they may not necessarily be the COVID virus itself. But of course, you know, 'tis the season. So I am believing for your full unmitigated recovery and just the overall mental and physical wellness for you and yours. That said, I am going to do my absolute best to get in and out in an hour because I can tell that I've done maybe too much this morning and I'm not feeling like, you know how you can think, okay, I'm feeling okay. I woke up feeling better than I did yesterday. So let me, go ahead and try to get all these things and get back into the swing of things. And it's just like, oh, maybe I should take it slow. But it is very necessary to keep you abreast of what is going on, especially considering there have been individuals that have asked me for updates as it relates to the racism that I experienced at Goodwill on Poplar Tent in Concord, North Carolina on December 9th, 2023. And as it relates to, and that was just generally. So I didn't go to Goodwill as a politician. I didn't go to Goodwill as a public figure. I went there as a regular patron. My family and I very regularly shop at the Goodwills in Charlotte and the surrounding areas. And whenever we're traveling, we're always looking for a good thrift shop, and Goodwills are, they're around the country. So we definitely look for those as well. We went to them out in California. If you remember, if you joined us in our cross-country drive to California when I graduated in July of last year, you will remember that we went to the San Bernardino Goodwill and found some really good stuff. But nonetheless, I didn't go there as a politician. I went there as a regular patron, and we were vlogging because, through my Tigress is a Verb platform, that's our personal professional platform for our Get Her Done family vlogs, which we are now calling Get Her Done Family Diaries. In sync with the trend, I like the diaries connotation as opposed to just the vlog. So basically, we were just doing what we normally do. And the Karens and the rogue racist police were doing what they regularly do. And in response, I did what I regularly do, and that is gatekeep the gatekeepers, because there needs to be checks and balances. That is holding people accountable to a zero tolerance policy on racism. And the policy is for Tigress Sydney Acute McDaniel, period poo, right? Not for a company policy, not for a political action committee policy. It is the policy that I have enacted, unilaterally for myself and anyone that I come in contact with. Like if you want to be racist, a lot of you know my views on racism. I just think that it is one of the most heinous things to just decidedly, unfoundedly, baselessly, closed-mindedly, hatred-filled, disdainfully, just I'm not gonna like these group of people because of their skin color, or their ethnicity or their religious affiliation. Like, it's exhausting. It's exhausting. And as a scientist, and with my Haitian and Native American values intact, I'm a steward at my core in both humanity and environmental sustainability. And this space, this is it for me, y'all. It's very scientific. It's very ethereal. This space that we live in, called Earth, is so beautiful in concept and reality. And I just can't process racist people. I can't process it. I can't process it. I can't process it. It is so unclear as to why they think they're superior. Like it just, and I digress, but just hear me out. Like, okay, so if we use sci-fi or we use, applied science, actual science, right? You have those in Germany, the white Assyrian, Aryan, I said Assyrian, Aryan nation, and they believe that they believe they are the superior bloodline, and they even believe that they, came from the stars, and no one else did, and they found us, savages on this planet, and they're better than us. Okay, so then, but why are you here then? If you're better than us, then there's like lots to do in the universe. You know what I mean? Like, especially if you're better than us, so that you're implying that you're advanced, right? And so when we think about aliens that would be advanced, and we think about humanoids that would be advanced, right? Then like get on your shuttle and go back, or go somewhere else where it's better. You know what I mean? Because you are best. So then go. Farewell. I just don't like, and that's the sci-fi end of it. And then the applied science of it is actually, I don't want to be that person, like check with Neil deGrasse Tyson, because he confirmed, and I know how y'all like, you're a science communicator. He's one of my favorite scientists too, even before y'all even found out about him. But yeah, like even y'all, when the caucasity folk, y'all even can't deny anything he says, and that he's confirmed that people that look like me, specifically Black women, specifically, like we actually possess all the genetic diversity that is the preset for human existence. Of course, aside from, our creator, which of course, Neil deGrasse Tyson, he's agnostic, not atheist. Or actually, I'm not sure if he's atheist or agnostic, but basically most of my fellow scientists do not believe in a traditional religious concept of God, if you will, right? I, however, do defer at the very least to the fact that I can't and could not have created any of this stuff. And thus, I have concluded that definitely there is a higher power, and I defer to that very, respectfully, very intentionally, very humbly. But basically, you get what I'm saying. Like, they don't make sense on any day of the week. That's the point I'm trying to say. Like, it's given, Cole, you stupid. Okay, so we're going to go ahead and I'm going to give the update on the Goodwill, which is pretty straightforward, y'all. That there's, you know, that it unfortunately takes time. That's the part of relief that, you know, legal relief, administrative relief, and complaints and all that kind of stuff that nobody likes. Nobody likes that process because you can be mistreated quickly. But then your relief comes later, if not much later, if not in worst case scenarios, not ever at all, right? So I'll give that update, and then I'm going to move on to the updates that are relative to my political platform as it relates to the gatekeeper order, which is wholly fraudulent. That was onset by rogue, racist, corrupt attorneys through attorney fraud, including Emily Jeffers Meister and Keith Black. And then it was fraudulently copycatted. So the information that, and some of you know this, you know this story, and hence that's the reason for the update through my political platform, because of course they have used that information consistently in libelous articles. Y'all have learned about the word libel. Some of you already knew it before I said it. It just means defamatory in writing, right? Slander is defamatory in speech. So they put in these articles that I have filed 172 cases. And this was prior to, 3 years ago? Because this article came out in 2018. So they said that I had filed 172 cases by 2018, and none of that is accurate. Now, I have filed more cases since 2018 because I am seeking relief from all the fraud that they are committing. And I do also have a few valid actions. Right now, I've admitted to it. I've told you over and over again that I have at least 10 pending actions, and a lot of them were delayed because of the fraudulent enforcement or the bad faith enforcement of the gatekeeper order. It's really fraud. It's not just bad faith. At this point, it's judicial fraud and attorney fraud, and I'll show you it's there. What I have learned over the years through behavioral psychology, through my academia, with my bachelor's degree in education, psychology, behavioral psychology is required. Most teachers can, affirm to the same fact, right? You know that if you've been through the field of education, behavioral psychology is required, proficiency in that, okay? Because it actually qualifies you, your education degree qualifies you to be a behavioral therapist at the very least, right? So I'm not qualified. I don't have the qualifying academia to pursue a license to practice, psychotherapy or, be a psychologist, but I do have the academia that would qualify me to be a behavioral therapist at the least. So, but the point I'm making here is that the conduct of these individuals is just so astoundingly shocking to any jurisdiction or the court's conscience. It far exceeds that. It far exceeds it. And so their behavior at this point is not just bad faith, and it has crossed over and into the realm that constitutes actual malice. So this is intended. This is deliberately conspired. This is calculated. This is, I'm trying to cover one fraudulent step with another act of fraud to conceal my fraud in general and evade liability and to deny her access to the courts, which is against constitutional rights to due process, and to even deny her fair hearings on her valid complaints, which causes a myriad of injustices that I have experienced, one of which includes my son, as you all know, how they trivialized that matter, my lawsuit against CMS, and Patricia Falk, the teacher who gave my son a food product with dairy in it against his 504 plan. He did consume it, believing that it did not have dairy because she told him that it did not have dairy, and so did a volunteer. What was the name? I don't have it in front of me, the volunteer. We may pull it up, but there was 2 volunteers at issue. And again, like I said, they had gone against the 504 plan. He did consume it. He did have an allergic reaction. He is seen by Levine's Children's Hospital. He did have to be seen. And after that examination, or which was expected based on the doctor advising me on what would likely occur if he, during the endoscopy, found that there had been inflammation stemming from this exposure to the dairy product, that he would have to go ahead and dilate him, because that's the best thing to do when they're already in the endoscopic procedure. He would have to dilate the opening to his stomach, and and he did. He had to do that, and then he had to come back and have it further dilated, because what happens for my son's condition, he has eosinophilic esophagitis, and basically that is, eosinophils are white blood cells. Esophagitis, most of you know, this is our esophagus, right? So basically for my son, what happens is that if you have an allergic reaction, generally most people understand this, you'll get hives. It'll be visible. You'll get hives, maybe red blotches, right? For some people who don't have eosinophilic esophagitis, what happens? Your throat may close, you experience things like that, maybe tightness in your chest, right? So for my son, it's always esophageal, right? And which also includes the opening to his stomach. And so what happens is it tightens, it restricts when he is exposed to an allergen. And in his case, he is deathly allergic to dairy. So when exposed to the dairy, then basically his esophagus, which they had already dilated over the course of like 2 years, and he was doing really well, that basically they erased all of that progress, and then we had to start again. So there's nothing about that lawsuit then that would be frivolous. There's nothing. At the very least, his medical expenses are definitely they're in the seat of CMS. CMS is liable for paying those medical expenses and our damages at the very least. And keep this in mind, they also perpetrated and defamed me, claiming that not only was the lawsuit frivolous, but that somehow I was trying to get money. That this is, every time I file a lawsuit, the whole game is, the whole aim is for me to get money, and in an unethical, way. I'm just, like a slip and fall litigant or whatever is what the kind of terminology is called in the field of law. And none of that makes any sense, because you guys, if you've ever dealt with or heard of someone having a lawsuit that involves the victim is a child, a minor, the court actually makes the judgment, they award the judgment, but that judgment goes in a trust, and it is not available to anyone until that child turns 18, and it is specifically available to the child at 18. And then if you've ever been in the court when this judgment is being read, the judge is very specific in making sure that the child, especially if they're over 8 or old enough to be able to apprehend what the judge is saying, the judge is going to direct their communication not only to their parent, but also to the child, especially if they're a teenager, because she knows, okay, they can appreciate, they have the cognitive skills to appreciate what I'm saying. And she's going to tell them, this is a lot of money that's coming your way. So when you turn 18, be very mindful, because this is coming to you. So don't let your friends get one over on you. Don't let any of your family members or anyone get one over on you. This is your money. And some of you're looking at this, you're like, yeah, you're right, Tiger. You're absolutely right. So then where would my come up be? My son at the time was 10 or 9 or 10. I can't count, girl. 2018. Give me grace. I'm going through a lot. So that was 5 years ago. Yeah, he was 9. He'll be 14 on January 18, 2024, which is next week. So I wouldn't have been seeing any money for a minute, even if I were to see it once he turns 18. Like, you see what I'm saying? Like, I wouldn't have seen it, because we still got 4 more years. He wouldn't even, I wouldn't see it. We wouldn't see that. It wouldn't go into my wallet. It wouldn't go to my bank account. There wouldn't be some Cash App jingle, you know how the sound makes, as soon as the judgment was made. That's not legal procedure. That's not how it works. And then if any of you have ever had medical expenses, like say if you've been in a car accident, most people know it from car accident claims, right? And let's say you have medical expenses and you're awarded by a court of law, your medical expenses are $10,000, right? You show the receipts to the court, they award you $10,000 for medical expenses. What happens to that? It goes straight to the doctor. And if you don't pay them, most often there's going to be a medical lien that they put in on a record proactively to make sure that money goes straight to them. So it's very unlikely, it's highly unlikely that it's ever going to pass directly into your hands. They don't do that no more. Your insurance pays out. I remember when I had that bad car accident, I actually received $30,000 from Geico back in 2011, right? And I would say, what was it? I want to say it was about $12,000 in medical bills. Oh, honey, they had a medical lien. That went straight to them. When the insurance adjuster cut the check wasn't for $30,000. It was for the deduction. You know what I'm saying? The amount remaining after the deduction. So the point I'm making here is that even if I had received an award for his medical expenses, which are $11,000, and they keep incurring interest because I haven't been able to pay them down. Remember, I've been in law school. Where I got $1 million from? I ain't got no $1 million. Most of us don't just have $11,000 sitting around. I don't have it. So it's been under my Access One. And Access One is not very happy with me because I was paying the minimum payment every month. Which is about $80, $90, $100, because it would fluctuate because I would also add my other medical expenses that weren't covered by my insurance onto it or whatever. But the point I'm making is that not frivolous. So we're going to jump over to that as well. And I'm just going to give you the quick updates and show you how they're starting to make foolish mistakes. Because again, as I was referring to before, early on with my career, I applied my academia of behavioral psychology to my position as a federal park ranger. And I had to assist law enforcement. Part of my duties were to assist law enforcement. That being said, I learned a lot on the job. I learned a lot about criminal psychology on the job. And one thing that I've learned is that people who really, when they're criminally minded, have that enterprise, that conspiracy level of criminally minded, they start to make stupid mistakes. because they're becoming erratic, especially if the victim doesn't become erratic or try to take the law into their own hands or whatever. The perpetrator begins to make stupid mistakes, and that's what they're doing. It's just straightforward. They're making really stupid mistakes, but conversely, it's good for my justice. So that's what we're going to go over, those two things. And you'll see what I've done as it relates to fighting the gatekeeper order, still fighting the wrongful conviction in 2006. I did not steal anybody's identity. I've done things in my life that I am not proud of, but I have not ever taken anyone's identity, nor did I, and I did not steal Teresa Rickman's identity. And still to this day, no Teresa Rickman has ever come forward because, number one, evidently there is a Teresa Rickman somewhere because she was actually a patron at my bar in Louisville, Kentucky. And that's where the license was. You see what I'm saying? And this is what was used as evidence against me. And it was like, it wasn't like I was being railroaded. They were trumping the charges and you know, and trying to railroad me under something that they knew I had not done, because they knew that the DA during this trial had moved to dismiss the entire case for lack of evidence, because it was 30 some charges that I was actually facing. Some of you know this story, some of you don't, but I was actually facing like 30 some charges, and I was forced to represent myself. It wasn't something that I wanted to do, but Judge Spainhauer refused to allow me a continuance to actually obtain representation, which is also unlawful when you're talking about a crime that entails active jail time. There's actually a stipulation in law against this. It's not just inherent to due process rights. Like there's a stipulation. You know you are entitled to representation, and y'all already know that. It's yeah. So I thankfully did have some legal background, because remember, I had started law school in 2002, but then had to drop out because of being in a car accident, having to learn to walk again, and then my dad passing away, all the things. But I was already legally inclined. So I used that skill set and was able to have, I mean, I chopped them down. Like it was like a Elle Woods moment, like a Ella Woods. It was just like that. And I was fighting for my life. Like, you got me in here for 30 charges. You sound like, excuse me, because I was about to, no. I know you ain't got me in here for this. And so, yeah, I fought hard, and it was like we went through every charge. It was, I was handling it very enumeratively, very precisely. And it got down to the third, it was only 3 charges left of obtaining property by false pretenses and 1 charge of identity theft left. And each one of them had been dismissed. Hold on, y'all. Each one of them had been dismissed, except those 3, and that last one of identity theft. They had been dismissed for lack of evidence. So obviously, at this point, the DA has no sufficient grounds to, continue trying to litigate or prosecute these criminal charges. And so she took the L that she should have taken, and she gave open court motion. Open court motion just means that she didn't handwrite it previously beforehand and turn it in or file it with the court, and then it was scheduled for hearing and blah, 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 blah. You do it right there in the moment. And she made an open court motion to dismiss the entire case against me for lack of evidence, since they had no evidence for the other charges, which allegedly, according to them, occurred in the same incident. So if you don't have enough evidence for these 27 and it's the same incident, then you don't have anything for these 3 And this won. And then the Judge Spanghauer, said, I will not receive, I'm not accepting that. I'm denying your motion, and we're going to proceed, and we're going to close the arguments. Like, he shut that shit down. Excuse my language, but he shut it down in the most good old boy, racist, Caucasian way that only some of the judges who remain in office and should not be in office have enjoyed for way too much time. Way too much. And it was an all-white jury. I contested that during the what is it called? The VOIRE, VOIRE. I'm very not that great at French dialect. I'm definitely not that great at I was going to say dire vor, and it's backwards. Void dire, which is the selection or the preliminary examination of witnesses or jurors, right? And he shut everything that I guess he was shocked that I would even be aware of that, and he shut that down too. Nope, I'm keeping everybody that's on the jury, and that's that. So there were so many violations of my constitutional rights, so many. It was just bad. And so I'll give you the update as it relates to that as well, because I tried expungement because I knew that would be the quickest route. But because of the classification of the felony, so the obtaining property by false pretenses, those three are misdemeanors. The identity theft, I believe, is a class I felony. And so at that classification, expungement is not available. And I'm not asking for a pardon because I didn't do it. So I'm not asking you for a pardon. You need to take this off my record. Okay. All right, so let's start with because I'm going to try to go and get off of here at 2:00. It's 1:18. I think I'll be able to do it. All right, so Goodwill. Let's go to it. Let's go to email, and I'm just going to show you the stuff of stuff. Let me see here. Give me 1 second so I can keep it concise. And I sent the complaint in through my ethical gatekeeper email. I thought it was more appropriate to do it that way. So hold on 1 second. Ooh. Yeah, let's try this way. Excuse me. Okay. Alrighty. Okay, let me share my screen. All right, we got the screen sharing. So let's pull up. Sorry, it's toggling. Just give me a second. All right, come on. All right, let me stop it and then try one more time. It's still toggling. If I have to, I mean, you know, they don't call me Queen Get Her Done for no reason. So, ain't none. We will pull it up from here. Ain't none. No problem at all. No problem at all. Okay. Let's get, okay. So, until that comes up, we'll do it this way. All right, you see the January 11th, which was yesterday. I get a message, Lori. Director, Brand Experience, Goodwill Industries of the Southern Piedmont, right here in Charlotte on Wilkinson. You know, their corporate center. I'm familiar with it. Most of us are. And it says, hi, Tigress. Thank you for sending us this message. At Goodwill, we take seriously our responsibility to create an environment that is welcoming and inclusive and where everyone is treated with respect, with the respect they deserve. We are sorry if we fell short of that. It wasn't just falling short. And behavioral psychology also teaches that when someone acts like she did, she has very typically acted that way and got away with it before. She was too calm. This was not like there's a law. You all have heard of the rules of hearsay, right? And generally hearsay is not allowed, but then there are exceptions. One exception to hearsay is excited utterance. And the reason being is because in behavioral psychology teaches that when someone has, if they react to something and it is especially passionate or the rage, it is generally because this is a new, unexpected stimulant that is causing them to act, in a heightened manner. Because if they were expecting it, generally your average person, if they're expecting it or they have behaved in a certain way and had experienced the same stimulant, and I'm referring to them as the stimulant, if you will, you know what I mean? That they would then be able to handle it better and thus be more composed in their response. And you'll notice that Karen Anna was very composed in her response. And she was giving me such arrogant, like she was giving me Trump, like I don't care, even if I sound stupid, I'm right and you're wrong and no one cares what you think and you're just a stupid little black girl and I'm calling the cops on you and you don't even know it and I'm banning you from the store and you don't even know it. And that's what she did. And what you see from me is excited utterance, because I'm like, you have got to be kidding me right now. You've got to be kidding me. You see me on video. What am I doing? Honey bye. And I'm sick of it because you have two cops. They were ready to arrest me and very likely harm me in such arrest. Or at the very least to mishandle me, not be kind with putting the handcuffs on. They were ready. They were just going to be belligerent toward me and didn't even have the story straight. A lot of you also know how much I love my son. And so you want me to believe that, that I'm out here acting the fool with my son and my mama? Now, I am definitely, without question, I'm definitely consistently a positive confronter. If you want to say I'm assertive all day long, don't call me aggressive because that's not appropriate. But I am definitely going to stand my ground when it comes to injustice, and I'm definitely going to speak up. I'm definitely going to fight for myself every day of the week. And I'm also going to fight for the little guy, quote unquote, every day of the week. That's what I'm known for. But this is the first time that I've even felt such frustration. Like, what in the world? You're not coming here to look into racism. Just like I said, you're not looking for racism. You're not. You don't care. You were ready to arrest me. You don't care. So they didn't just fall short. So I don't really like that part of the email. I don't like that part because they definitely, when you're in corporate America, there are certain skill sets that are expected of leadership. And so word choice, your diction, and being empathetic to complaints when you receive them. I gave her sufficient enough information, and I'll make sure to include the complaint that I sent, because we won't read through well, I guess we could. Let me see. It shouldn't take too long. Let me see. But yeah, basically they had sufficient information to know this ain't right. This ain't right. And so I'm just gonna, I don't know, it's still toggling. This is crazy. It's not even gonna let me. I don't want to end the stream either. Hold on, y'all. Let me see if I can. Yeah, I'm on. Yeah, see if I end the stream. But like I said, you know what? I can definitely make it work. Don't get it twisted. So basically, I'll read it to you. And we'll go through it very quickly. On December 9th, 2023, I visited the Goodwill store located at 5511 Poplar Tent Rd in Concord, North Carolina, and was subjected to grossly egregious violations of my inviolate civil rights under North Carolina and prevailing federal laws against racial discrimination and malicious prosecution, and or falsified 911 calls motivated by racial prejudice. That statement alone was sufficient enough for her not to use fell short of. Like, that was not the most empathetic statement to make. Below, find details of all that occurred. Number one, myself, my mother, and teenage son entered the store at approximately 4 p.m. looking for a winter coat for my son and otherwise regular thrift shopping as we customarily do. We as a family are vloggers, so I was recording us with my iPhone camera as I customarily do. I, separate from my family, am a public figure in both community civil rights activism, entrepreneur, and local aspiring politician, having vied for office in Mecklenburg County and the city of Charlotte, but not yet elected today. That was another signifier for her not to attempt to insult my intelligence or my rights generally by speaking to me in a very pacifying way. Like, it reads, it's giving disrespectful. It's giving, did you really experience racism? That's what it's giving. So it's giving more Karen vibes than anything else. So we'll see. Number 4, as frequent Goodwill shoppers, I've observed and concluded that your stores have limited apparel for teenage boys, and instead, more often abundantly, have either infant to boys apparel up to about age 10, 12, and 12, 14 size-wise correspondingly, or that for adult men. So accordingly, in looking for a coat for my son, I immediately visited the children's section and was excited when I found 2 coats that looked like it fit my son. As you can see in the video I captured, and I gave them the link on TikTok, because we were vlogging, it is conspicuously evident that we found at least one of the coats. You can see that we got one of the coats without question from the children's section. You know, I'm just saying, even though we got them both, you can definitely see on camera that I at least got one from that area. Number 7, because the 4-pocket military coat jacket appeared somewhat feminine, I asked my mother for her professional opinion as a retired seamstress. Number 8, she also suspected it might be a woman's coat jacket, so I asked the Goodwill employee, that's the black man, the elder man that's sitting in the chair in the video, who was working near the children's section to confirm the gender and price for the coat jacket. This Goodwill employee can be seen in the video seated in the chair when the manager, Anna, is talking. Number 10, he did confirm that both coat jackets were indeed children's apparel, but didn't comment on gender, and did otherwise also confirm that the price for each was $3.99. Number 11, I then proceeded to pay at the front registers and immediately shared with the cashier what the other employee had affirmed that both coat jackets were $3.99. I even pointed out that employee to the cashier to verify. Number 12, this cashier, the Caucasian woman seen in the video, exclaiming in a flippant manner, "Bye, you ain't doing nothing to me," then rudely interrupted me as I was sharing that stated above, causing a scene, accusing me of lying about the placement of the coat jackets, and even loudly exclaimed, "You people move stuff around in our store all the time and tell us anything trying to get a cheaper price." To which I immediately and justifiably responded, "What people exactly?" Yeah. Okay. Number 15, I then demanded to speak to a manager regarding her racial remark and asked that the Black male employee who confirmed the price also be called to the register for verification. 16, oddly enough, the cashier beside her, the Black woman you can see, which is in the thumbnail, an older Black woman who can also be seen in the video standing near the other cashiers I'm leaving out, interjected forcibly. And when I tell you she was acting like a whole Sambo, like, y'all, she was running around. Excuse me. She was running around the store, holding up. It was, yeah. She was exclaiming loud that while holding out the hanger on minstrel display, these hangers, or these, she was saying these, but she was referring to the hangers, are adult hangers, not kids. So yeah, she got those from an adult section. I was just like, this is what we're doing. Okay. Number 17, to which I immediately responded, "You've gone too far, and that's a lie from the pits of hell, because every garment I pulled off the children's rack just now had the same type of hanger, and I didn't even know that, and I didn't even know that you, Goodwill, had kids hangers versus adult hangers." Number 18, I then took the coat jackets and walked back to the children's section to find the Black male employee who had confirmed the price and also to await the manager. 19 minutes later, the manager, Anna, approached me and she immediately began to berate me about how people do move clothes around all the time. So why do you take an issue with her saying that? And then, well, I'll continue because I'm going to say, yeah, I say it in here. Number 20, when I iterated the obvious in the cashier's remark, "You people," is a commonly disdained remark due to its inherent racial prejudice or prejudice in general against any particular group of people, she not ever apologized nor took accountability as the leader of her staff for the grossly inappropriate and unlawful conduct of her staff, and instead began a considerably odd lecture attempting to psychoanalyze me. I was just like, wow. And I hadn't, at this point, so it's already unfoundedly insulting because she arrogantly was projecting herself as more intelligent than me. And the sheer irony is that you're standing in front of someone who effectively has 2 doctorates and street intelligence to boot. Like, I have common sense, intelligence, and book smarts. Like, here I am, a PhD candidate. Because I hadn't said anything about it being a lawyer. Please understand, I didn't say that I was a lawyer until I was confronted by the officers. You understand? And how they and because of how they were treated. So I didn't say nothing to Anna about that. Okay. So here I am, a PhD candidate in applied science and recently conferred Juris Doctorate, just shopping with my family and having already maturely and objectively sought confirmation for the price of the coat jackets, being berated by the manager in a despicable demonstration of unfounded arrogance and unmerited scrutiny, and accused of lying about the placement of the merchandise to get a cheaper price. Girl. Number 22, I even pulled the other garments that I had looked at and then rehung when deciding against it, which were also markedly hanging on the bigger adult hangers. But Anna remained accusatory and dismissive in her look and tone of voice and remarks toward me. So all of this now will make sense with her body language and her the way she was talking to us. It was very condescending. It was just ridiculous. Number 23, and again, unfoundedly arrogant. Like, okay. 23, it was also especially disturbing, not only for me, but also for my teenage son, who was effectually forced to witness and experience it all. Number 24, as can be seen in the video, my mother then asked her to simply confirm the price, to which Anna initially responds with hemming and hawing. You heard her, stumbling all over her words. And then a menstrual examination, like she's looking at the coats like, oh. At which point I just resolved the matter myself and stated, I have the money, but you can keep them. It's all right. Because it was crystal clear that she was motivated by racial prejudice. Immediately thereafter, I proceeded to exit, as you saw. Like, that's on camera. Number 25, I was also surprised at her persistence in ascribing some criminal or unethical intent and or conduct to me, because even the black male employee, confirmed that he had seen me pick the coat jackets from the children's rack, that the hangers, although the big ones, were indeed with the coat jackets when I picked them up from the children's rack, and that he had indeed told me that the price for the coat jackets was $3.99. So that should have resolved everything. Even if she was like, okay, well, I apologize for all these things. And that could have been a way to resolve it amicably, the right way, against injustice toward me. Ma'am, I sincerely apologize. We do absolutely have two style hangers. I apologize that the cashier spoke to you in the manner that she did. But even though she was wrong in her delivery and the racial innuendo, which I will address, she was correct in that we do have two styles of hangers, and this coat comes from the children's section and it may have been misplaced. We're not accusing you of misplacing it. We understand that someone has seen you pick these coats up, and we acknowledge that. But at the end of the, and I wouldn't say at the end of the day, because we all know that is offensive too. But the coats are adult coats or adult jackets or whatever she said, and the price is going to be $6.99 or $9.99. Boom. Then I could have very easily just, okay, I'm going to make a decision. Do I still want the coats? And I very likely would have still gotten the coat because it was $7. Yeah, because now that I remember, she said that they were jackets. Remember, if you go back to the video, she was like, yeah, they're jackets. And yeah, something's going on because I hope I'm still live, because even let me see. I'm gonna read this out, and then I'm gonna go to YouTube to make sure that you're seeing me, because my computer is not even registering the time. It's stuck on 1:27. And I don't want to end this and then resume live. I want to make sure that this is all. So I'm going to check it here in a second. And if you would please comment from YouTube if you're watching this, it would help me out a lot. Okay, so then let's see here. As I exited, I saw a police officer, which is also captured in the video. And in shock of the grossly inappropriateness and unlawfulness in them calling the cops on me, I asked for the officer's card. Number 27, as you can see in the video, neither of the Caucasian male officers approached me with objectivity, and instead had already assumed that the call they received was legitimate and true, and further that I somehow posed a threat or actionable criminal disturbance, and none of that was factual, and thus constitutes effectual malicious prosecution, and alternatively, more directly, a falsified report to law enforcement, which is unlawful and actionable under criminal law in North Carolina. Before I go on, let me check and make sure that I am live on YouTube. Oh no, I don't think I am. No, I'm not live. So I lost y'all. Hold on. I'm going to end. It's not even allowing me to end. Oh, this is not good. Wow. Okay, it's giving me the impression that it's resuming it. I hope that it does that. Then I'll update my post to show that it is continuing. I hope that that's the case. That would be awesome. That would be the ideal situation because it is still showing that I am live on YouTube. So let's go with it. I'm gonna check one more time. So give me 1 second. Sorry about the pause. You'll understand the pause in a second, though. You'll understand, and I'll make sure that I timestamp the pause so that you can just skip ahead to when I resume. But give me 1 second and make sure. And actually, I'm going to take this moment to get some water as well. Yeah, it's still showing that I am live. Yeah, it's still showing that I'm live. Let me make sure. Let me double check one more time. Okay, it's giving me the impression that it's resuming it. Yeah. I hope that it does that. Then I'll update my post. That's awesome. So let me update my post real quick because I can just take this out. Let me just edit it and say, I put my broadcast appears in my MacBook froze. And I had to restart it. And thankfully, the live stream resumed with only a pause in the broadcast. I'll timestamp the pause in the description box so you can fast forward from when the pause begins to when I resume. There we go. All right. Yeah, thank goodness it was recording and did properly record completely, even after I disconnected to restart. All right, so let me put that there, take that out. And I know a lot of you are probably working, you know, I'm self-employed, so, all right, let me put that there. And because of this, I guess we'll be online until 2:30. Like I said, the other stuff, it's going to go fast. Just hold on 1 second. And a lot of you don't want me to go fast. You want me to be thorough. So I'm being thorough as well. Make sure I have this here. But I'm glad it didn't. I'm glad it didn't do it in twos, so I don't have to do any extra work. Because I really, once I get off the line, I'm going to make myself some hot tea and lay it down. I need to get some more honey. I've been going through the honey, you know, for obvious reasons, and I'm all out. And I really need some honey, but I do have some lemons and I have some good old ginger tea. And so I still have my essential oils, so that'll work out. Okay. All righty. So now we're back at it. The good thing is now I should be able to share my screen. I don't know if that caused the hiccup, but we're going to try one more time. Let's hope for the best. So give me a second. Let's share screen. Oh, maybe that's what I did because I chose something. I chose window, and maybe that's what was the hiccup because it's sharing this stuff now. Let's hope. So maybe it was my fault. Okay, we're going here, and let's go to the email. I believe that's the right one. So get out of my business. Get out of my business. Well, we're going to be going to that anyway. So let me just go here. All right. Okay. All right. So yeah, so you should be able to see this now. And actually this also, like, I'll be able to give you the update as it relates to this as well. This is what I was telling you about. They've given me the date and time to join via Zoom. This is related to Shamika Smith, my previous member of the ethical gatekeeper who committed fraud in her child custody case. And then because she violated the terms of the membership agreement, which also give notice that if a member is discovered to be committing fraud through the membership benefits, that it will be reported to the authorities. And so not only did I report it to the authorities, but I then testified by subpoena, by way of subpoena from the father of her child. His attorney subpoenaed me to give, testimony regarding the fraud that she had committed before the court. So in retaliation, unlawful retaliation, which is a form of malicious prosecution, in addition to her filing 2 frivolous temporary restraining orders, both of which were denied, she then submitted a complaint to the North Carolina Bar Association, falsely alleging that I had committed the unauthorized practice of law. Okay, so yeah, that's what I'm dealing with, people. All right, but yeah, so this one here, okay. Here we go. So we got Samantha Story and Kelly Ford and Meredith Robinson are the individuals that she CC'd. And like I said, you see that. I do appreciate her saying we're sorry. She was very straightforward in that regard. But if we fell short of that, she could have just said we're very sorry, because he had already said that we take this stuff seriously, be welcoming and inclusive. And I already know that about Goodwill. I don't think that they were acting, even though they're agents of Goodwill by law, it's very clear that they were acting beyond the scope of their authorization, and authority based on the Goodwill model. So that is a mitigating factor for Goodwill, without question. Oh, without question. But it doesn't give them absolution. And they need to do something about it, because her act was really, really terrible. And based on also looking at the Yelp reviews, because someone who liked my video on TikTok and commented, they actually commented with the Yelp reviews linked to that particular Goodwill, and other people had similar experiences, but they didn't chalk it up necessarily, to there wasn't a cop called, but they were saying, just like I've mentioned to you all, that I vaguely recalled having to deal with her once before, and she was very just generally rude. Like, she just has poor customer service skills in general. And remember, the very explicit racist comment came from the cashier. And then Karen Anna took that, and then all of her conduct was impliedly racist and unfoundedly condescending. So you get where I'm coming from. But anyway, the fell short of it just wasn't appropriate. She could have just said, okay, you weren't treated with the respect you deserve. That That's straightforward, period. So where everyone is treated with the respect they deserve. So we are sorry and want you to know we are looking into this matter further. Fell short of, it's on record. Yeah, you fell short. Calling the cops on somebody over what effectually is a price check, no bueno. No bueno. No bueno. No bueno at all. All right, so then you have that. Let's go down here to complete the what I and I believe I stopped at, let's check just to make sure. Well, I won't be able to see it, y'all. I just thought about that. I won't be able to see it. Sorry. Okay, right here. Okay. I believe I was at, because I think I said 19 or something. And remember, all of it is captured. So let's see. Where was I? Yeah, right here. Number 26. As I exited, I saw a police officer, which is also captured in the video, and in shock of the grossly inappropriateness and unlawfulness and them calling the cops on me, I immediately asked for the officer's card. As you can see in the video, neither of the Caucasian male officers approached me with objectivity and instead had already assumed that the call they received was legitimate and true. I have not heard that call yet. So I don't know exactly what was said, but we can infer. It's a valid inference that we can pull from their conduct and how they responded to me up front. And further, that I somehow posed a threat or actionable criminal disturbance. I think we were there, actually. I remember reading that part. And none of that was factual and thus constitutes effectual malicious prosecution. And alternatively, more directly, a falsified report to law enforcement, which is unlawful and actionable under 14-225. Yeah, I did read that. Last statement here, number 28, the Caucasian male officers, Brown and Yates, and one of whom identified as a supervisor, Franklin, were all fired up to arrest me without even probable cause of any criminal violation, having no knowledge of what had factually occurred, nor even showing any required inquiry into what factually occurred, and instead just wanted me to leave and shut up, and hypocritically and prejudicially berate me for being a lawyer and adult, but not acting like it. The entire ordeal was just so immensely bad that it has taken me a full month to compile this complaint and submit it. And that's true, because it's just been so much. And I must admit, and I think I said that in one of my posts, I didn't realize that it was going to go viral. I hope that it would definitely get a lot of eyes on it in my, immediate reach, in Charlotte and of course in Concord. But I'm very thankful to you all who have shared this post and the reach that it has gained. So thank you very much. I appreciate that. I'll be honest with you, with everything that I've been dealing with on the political scene, I've been very concerned. And if you go back to my previous broadcast, you'll see that it's not so much as that I lost faith in you all. And I appreciate those of you who have just you've been consistent in your support and your actions, line up with that, because you're actually going out to vote. But it just seems like more and more people are disenfranchised and disillusioned with the political system. And of course, that's understandable. But how we're going to make any changes, because this is the law on the books. As I keep reiterating, this is how we get things changed. We can't just even the racist white people couldn't effectuate a successful coup. The January 6th idiots, they couldn't even do it. Trump can't do it. And we already know, we joke about it. We talk about it in a, kind of like sarcastic way. If we had done it, speaking of Black America or diaspora America or brown America, honey, they would have been shooting us, right? Tear gassing and shooting us on spot. So we can't effectuate the change that we want to see, the reform that is necessary, through a coup. We have to go through the legal steps that are already in place right now. And it's unfortunate in one regard, but that's how it goes, right? And so I've just not felt like I've had, your support the way I needed. And so for that reason, understandably, I didn't expect for it to get as many eyes on it. I knew that it would get eyes on it because I've got a pretty good following, but over 10,000? Nah, maybe not even over 5,000. To be honest with you, I was thinking, yeah, okay. When it got up to like 1,500, normally most of my posts stop around, if they're gonna go, into the thousands, they stop around 5,000, right? And most often stop around 1,500, 2,000. So 150,000 on one platform, another 150,000 on another platform, 80,000. Like, thank you. So when I posted the video on that same day, December 9th, I didn't expect it. Like I said, I did expect it to be seen and even seen it at large in the greater Charlotte metropolitan and beyond, but I didn't expect it to go viral. I'm glad it did, because the support and solidarity from my fellow Black Americans and allies was healing amidst the anguish and anxiety I suffered at the hand of your employees and the rogue racist Concord police officers who showed up willing to corrupt their oath of office at my expense until I acknowledged that I was a lawyer. I hereby demand the following forms of relief. Number 1, termination of Anna and the 2 cashiers. And number 2, a formal letter of apology. And of course, I selected that I want to receive updates. So that is the update in that regard. That is the full, and I drafted it like a lawyer would, because I'm a lawyer, even though I'm not a licensed attorney. That's what I've been trained to do, to draft it in a very concise, enumerated fashion, like a facts, the history of the facts, and that's what I did. So it's there. All right, let's move forward to now. And of course, it's going to take even longer as it relates with to internal affairs, because we know they don't move fast either. So we'll see about that. I'll keep you informed. Please do use the hashtags racist Concord police and racist. What did I put? Hold on, let's go to it. Hold on one second.
Screenshot and then could be linked.
Hello. Happy Friday. Oh yeah, please use
there. Again, I want to
please use
immediately start this off.
Please use the hashtag Goodwill Karen Anna and hashtag racist Concord police when you repost my updates, because those will be the hashtags that I have uniquely set up so that you can keep abreast of the developments in this regard toward my justice, unmitigated justice, because I don't believe justice is justice if it's mitigated. Okay. All right. So now we're going to go to, oh yeah, this is just, honey. All right. So we're going to jump over to the political side and the gatekeeper order, the fraudulent gatekeeper order and bad enforcement thereof. Okay. So let's go over to, I need to get to my, here we go. Perfect. All right, so we're going to go to, I think her name is Brianna. Yeah, no, Brittany. Okay. So on January 2nd, so the original case number, and a lot of you are familiar with the case numbers. At the very least, you're familiar with the fact that, and I'm circling this here, that the first 2 numbers are indicative of the year that the case was initiated. And then the CV refers to a civil case as opposed to CR refers to criminal. Then the S refers to superior court as opposed to district. And then, of course, if it were a small claims action, then it would say CVM, M for magistrate, okay? So this case number is indicative, and arguably indicative, that it was initiated in 2013. I started running for office in 2013. This is all politically, no, this is not the time. No, it is all politically charged. It is all stemming from political bullying. It is all stemming from a smear campaign. It can't be separated from it because I'm going to explain this. Hold on one second. He's making, remember I'm at home and he's making chicken nuggets. Actually, this is a great time for me to get a refill on water real quick. No loud screaming or anything like that. And don't make too much more noise. I should be done here in a second. Okay, and so in the most concise manner, some of you know the story, some of you do not. Okay. Okay. I visited, so in 2013, I ran for office for the very first time. And I immediately became the hot topic because, of course, when you run for office, you must file a disclosure statement if you have been convicted of a crime. We already know that I had to deal with the wrongful conviction in 2006. And so I voluntarily reported that in that disclosure form when I filed to run for office, which to me was no big deal because it had been something that had already been, I had already publicly shared. I knew that I would be under some form of scrutiny. Of course, I'm not an idiot. It would be irrational for me to believe that there would be absolutely no scrutiny of that disclosure. But just as I stated in an interview, which is on record in the News and Record and other publishing, other publishers or whatever, I believe my response was to this effect. People that know me know they immediately dismiss that as not associated with my character. And I believe that I can show and tell with my actions and my consistent behavior and character, I can show Guilford County that I am exactly who I say I am and that they can disassociate me with that wrongful conviction. Or more accurately, they can disassociate me with that conviction being an accurate conviction, a valid conviction. And so I just kept it moving after that, and unfortunately, of course, you're going to have, if there's already an agenda to keep out someone like myself, because the irony is prior to running for office for the very first time in 2013, I actually had excellent rapport with the Guilford County Courthouse. As a local business owner, I would periodically have or initiate small claims actions where there was the off chance that one of my clients was slow pay or didn't pay at all. And I would sue them in court to get them to pay the money that they owed me for consulting fees and, and other services. And I regularly won because I kept good records and it was a straightforward type of case. Like, contract says you pay, you didn't pay. And it wasn't one of those type of situations. I not ever had a client that was like, I didn't pay because I was in a car accident. I'm not that person. I'm not taking you to court if you had a life circumstance that caused you to not be able to pay, because I'm very understandable in those type of regards. I only took people to court that actually owed me money and they were with the shits and didn't want to pay, and thought they were going to get away with it. And so I pulled them in court because you are going to pay. Okay. So that's the history that I had. And I believe his name was, I want to say it's Magistrate Mevin. I'm very certain that was his name. I'm an older Black gentleman, and he would comment very often on how professional I conducted myself. And then Sharon Allgood. Sharon Allgood, some of you know these names when I'm saying this in Guilford County. Sharon Allgood was a long-standing administrator, an administrative assistant, judicial assistant. I want to say she was an assistant to both both district and superior court judges, because it was one chambers that I recall. And I was so well respected and we had such a good rapport. If I needed to go into the magistrate chambers, I could, because in Guilford County, they actually had a chambers, an area where you had the offices for the magistrates. And then they also had a separate area on the off chance that like I had something that exceeded, the threshold for a small claims action, then I could file it in district court. And I very, very frequently in those periodic cases would communicate directly with Sharon Allgood, and we had an excellent rapport. Okay. So none of this, all these allegations of she's belligerent and she's filing frivolous actions and she's harassing us through the court system. None of this started until Emily Meister. It's a very specific start date. It's very finite. You can see it. The lines are very clearly drawn between the beginning where everything was perfectly fine, or at least professionally fine, right? And then, because we weren't just professional before 2013, and nor were we fraternizing, but I had a rapport with them where it was kind. Like we could, how you have a professional rapport with someone where you just keep it a buck, right? But it wasn't just a buck. It would be like, hey, how you doing? How's the weather? It was more, kind of surface. We didn't talk about each other's families and none of that stuff, but it was pleasant. We had pleasantries and professionalism prior to 2013, okay? Me and my friend at the time, good friend of mine, and she actually provided witness. A lot of people misunderstood that somehow I was at this restaurant by myself with no witnesses, and that I sued the restaurant over a 2-cent tip, right? And none of that. Oh my God, honey, none of that happened. None of it. Okay. So basically at Ham's restaurant where me and Alexandria went to eat, first of all, she was already like giving us the whole, black and white. Y'all, like, like we weren't there as a couple, but it was still, our server was on some stuff. She was on some racist stuff off gate. And so when it was time to pay, she didn't know this, but I had every intention. I think I had cash or something like that, or Alexandria, because me and Alexandria, we were not broke at the time. We weren't broke. We weren't rich at the time, but we weren't broke. And I had my son, and I was actually, I think the year after is when I opened Passion Live. At 316 South Elm Street. Some of y'all remember that. So I wasn't like broke. And it was also around the time, remember 2011, I had the car accident, got the settlement from Geico. And this was also around the time that I had resumed my academic career at North Carolina A&T State University. So I wasn't rich by any stretch of the imagination, but like I could tip. I could tip, and remember I worked as a server. So I am intentional about tipping. I can't leave you a $20 tip, $30 tip on a $10 meal right now. That's not my lifestyle. I can't do that right now. But I am always mindful to leave a decent tip. What I'm getting at, fast forward, is she came back and she had done something with the check and where she processed it. And she had actually processed it with a tip. And it's just us two. So we're not in a group, and it wasn't a high volume time frame. You know how sometimes there's a high volume time frame and there's a fine print that says if you come during this time frame, there's going to be an automatic tip included and all this kind of stuff. And I take great offense to that because there are laws against that. Okay. So I brought it to the attention of the server. She gave me all kinds of, she gave me and Alexandra all kinds of nonsense, all kinds of back talk, right? So then I was like, okay, so I brought it to the attention of the manager, and between the manager and the server, they basically were like, oh yeah, Black people don't tip. Boom. Okay, so then it became racial discrimination, all right? So at that point, I was like, okay, and they were like, yeah, we're and we know who you are, because I had just filed to run for office. So I was like, oh hell, here we go. So I knew that I would actually have to, like, when you're a public figure and you are accused of something, you unfortunately, even if you want to not have to like make a statement, you have to make some type of statement at the very least to effectually clear your name. And so considering everything that I was experiencing, I did file the complaint for racial discrimination, right? And they tried to say I was suing for 2 cents because that was, that was the sensationalism of the story. So there was an article that went out, and actually, let me see if I can pull it up on Google, because some of you are not familiar with this. Candidate sues over 2 cents. Let's see if I can find it. 95 cents. Here we go. I don't know why I was thinking 2 cents. Okay, here we go. Greensboro News and Record. So some of y'all didn't see this and you're like, oh my God. So there's lots more to it. I don't want to sign up. Let's see if it gives me the option to go free. Let's go. One more. Sometimes if you... And this is also bad because they're actually getting paid off of me, and that makes it even worse. But basically, as you saw, look it up. I'm the person. This is from March 28th. And why do they have 2019? Because this happened in 2000. I was living in Charlotte in 2019. So evidently they've updated it. Yeah, I need to screenshot this myself and go back to this. I'll take the time. I don't, oh God, I had to wonder, let me see, y'all. Let me see, sign up for, I guess I was supposed to see this and do all of this today. You gotta be kidding me. Yeah, this is not good because I would have to enter my card number. I can't do this online. There's no way to do this. I can stop sharing and try. Give me 1 second, y'all. I'm gonna stop sharing. And let me sign up real quick so I can get access. Give me 1 second. This is crazy. I guess I was supposed to find this out. Let me get the other thing. Hold on. I was supposed to find this out. This is all 222, y'all. 222. 222. I was supposed to learn about this. This happened in 2013. There's no way that they can. It didn't happen in 2019. I was here in Charlotte. So we're going to find out what this is all about. Just give me 1 second, y'all. But basically, as I'm subscribing to this BS, I'm showing you how this has been all connected to a smear campaign and political bullying. And that's how it started, and that's how it continues. You know how they say how it started, how it's going. It's the same thing, and it's just a carryover. And it is a interweb of conspiracy through judicial and attorney fraud. And they have conspired steps, calculated full mens rea, which means full mental intent, of malice to subject me to very specific harm, discreditation, being public disdain, through the gatekeeper order and beyond, to make me look like I'm a babbling idiot, uneducated, and rogue litigant, pro se litigant with no education, and no good character, a deserved convicted felon. Honey, they have done a really good job, but their numbers coming up because it's not true. So, and just like with Kat said it, other people said it during this time frame, that the truth is at the forefront, in this year, at this time, this season. And in my case, it is no different. So just give me 1 second. Hold on. It is no different. I guess we have to go a little longer because we had the technical difficulties, and then now we ran into this. Hopefully we don't run into anything else so that I can just get on off and rest. But this is crazy. I'm eager to see this. And normally when you see a date that is different from the original published date, it's indicative that the publication retracted a statement or made edits. And I'm eager to see what they have said, because as you saw, which is now timestamped through the screen recording, that it shows a published date of March 2019. But this occurred, it was first published in 2013. It couldn't have been proactively published 6 years prior to the event occurring, in some type of psychic form. It's premonition, like that makes no sense. So it's an obvious discrepancy and change. This is crazy. This is crazy. And I'll go ahead and I'll go ahead and save this too. This is crazy. If y'all watching this with me, send me some love, honey. Send me some love, because this is crazy. This is crazy. This is crazy. This is real crazy. This is good and crazy. But they would have you think I'm crazy. And those who know me know you got the wrong person. It ain't me. It ain't me. It ain't me. All right, so $1 for 3 months, huh? What? Hold on 1 second. It's saying. Hold on. And $1 for 3 months. Let me see if it'll do Apple Pay. It wasn't liking my card, which actually I prefer that they don't have my card. Yeah, it's still saying error. That's hilarious. Why is it saying error? This is cray-cray. I'm trying again. Okay, y'all, it's giving me all kinds of headache. Let me see if I can pull it up through another. It's not even allowing me to make the purchase, and ain't nothing wrong with my card. Let me try another way. Hold on 1 second. Let's see. Yeah, they have evidently put all kinds of, like, there are several. I'm doing it on Google, but I'm not pulling it up at all. Okay, so I can't seem to pull it up, and I'm trying. Yeah, I can't. I've tried. All right. So for the sake of continuing this, because we're 1 minute 43, 1 hour 43 minutes, well over the time that I intended. Oh, why is it not letting me see it? And I can't quickly, like, it won't allow me to take a screenshot. I can't get to it. Subscriber login. It's not giving me an option. Let's see. I'm gonna try one other place. Let me try. Sometimes if you do it from council candidate, because I was running for District 1 against Bellamy Smalls. I did not win that election. All right, let me see if I can. Get in there. I'm trying to get it real quick. I almost got it. Hold on. Okay, so I was able to get a quick screenshot. Still don't understand why it's showing March 28th. Yeah. But okay, so let me go to this. I was able to get a quick screenshot and we'll read it together. All right, so it says, this is what I found. A candidate for city council is suing Hams, alleging deceptive trade practices and discriminatory practices. So you see what I mean? So it had nothing to do with just this tip. Don't believe that. Tigers McDaniel, who is running for the District 1 seat, said the downtown Hams charged her an automatic gratuity without previously disclosing its policy. She said the restaurant didn't return an additional 95 cents in the charge, and she is seeking $502. And of course, it shows you, hold on, that I will face Councilwoman T. Denise Bellamy Smalls and Sharon M. Hightower in the October 8th primary. Okay. And of course, then you saw at the bottom that that was from the Greensboro News and Record. So I don't know what they updated on March 19th. I've got a screenshot, and again, it's in this. And so I will post updates and give you updates on that later on. But basically, you're seeing that, wow, we didn't know all of this, right? So it wasn't like, it just didn't, think about it. It just didn't happen out of nowhere. You think I just like they were just like, okay, like it was very specific to this, okay? So Emily Meister, how does she come into play? She was the attorney for Ham's Restaurant. As myself and Alexandra were walking out of one of the initial hearings for that case, Emily Meister actually she verbally attacked me and Alexandria, and then she assaulted us. So assault by definition does not mean that someone actually has to touch you. Assault can also be where the victim apprehends a imminent threat, and it can be in communication, an advance towards someone, like that type of thing, and basically that's what occurred. She actually followed us out because the judge told her, because Meister said something about, well, I want to talk to them or whatever, and the judge said, well, you don't have that privy. If they don't want to talk to you, you don't have that privy. You'll need to just communicate through the pleadings. And so as we're leaving out, she was on her white woman tears and a white woman Karen mess. And she was like, y'all gonna talk to me? And I was like, no, we're not, especially with you coming across the way you are. Like, no, we're not. And we kept walking, and she actually, as we're getting on the elevator, she stops the elevator from closing and puts her hand into the elevator, and she's like, oh, I will take care of y'all. And I was like, no, I'm calling security, because now you've crossed the line. You've literally crossed the line. And remember, we're in the Guilford County courthouse at this point. So there's surveillance. It was recorded. This is not like something that I'm making up. She, of course, knows what the hell she did. It is it's just finite, okay? And again, Alexandria is with me. I'm not just by myself, right? So Alexandria is, she's co-signing everything. I'm saying, she's like, look, we need to get somebody to, take care of this, because this is crazy. And we had also learned prior to this hearing that I believe his name is Rocky Scarfone. And in my neighborhood, or in Guilford County, he's known for having very shady dealings and using mob-like force, mafia-like force to strong arm people and get them to do what he wants. And evidently he is or still is or was the owner of Hams. I was like, I don't want to know. This is not. I ran for public office because I was really one of the good guys, and I really just wanted to do something positive. That's it. I didn't get into this race to be in here with y'all to turn out to be one of those movies where the politicians are doing drugs and prostitution and going to orgies and in bed with the mafia, and then they get their hand cut off and then equalize. No, I didn't do that. That was not. No. Okay. So basically, we called for the officers immediately, because you could hear the ruckus. You could hear her yelling at us. It was other people that were walking around. They saw her, stop the elevator. They heard her. And I literally, at that point, because I could see, hold on one second. You done? Okay. I could see security. And so we both, Alexandria and myself, we said security, right? So again, you could hear the ruckus. Even though our voice wasn't ruckus in and of itself, it was still amongst the confusion, quote unquote. So your average person may not have been able to decipher between it. So that was our part in the noise per se, right? And Officer Flowers, or Security Officer Flowers, he showed up and he had to address her because she was still going in. And it was just, she was completely belligerent, completely out of line. And I even filed a complaint against her with the North Carolina bar. And she's just too tightly wound. She is part of the corrupt status quo, the good old boy system, and they protected her at all costs. At all costs, okay? And you can look up all the records. Most of it's, I would imagine that most of it's public record, if not all, okay? So fast forward, here I am in this situation, and at this point, I then file, because I don't know, I'm talking with my trusted loved ones or whatever, and talking it over with Alexandra, and we both agree to file a TRO, right? A temporary restraining order, to make sure that she keeps her distance. Like, this ain't what this is. We don't want this to go no further. Chill out, because this is it. This is it. Don't come near my house. Don't, like, this is over. Just like stick to litigating in court. All this other stuff, you taking law into your own hands and trying to threaten us on the like strong arm us. No, like, lady, please stop. So it wasn't just a suspicion. She was acting on those threats. And so that's why we did it. Okay. So then, and it's kind of like unfortunate, because it's like when you're dealing with somebody crazy, you're like, and that's why a lot of people who are in abusive relationships, or if they have been assaulted, they do their best to try to just avoid the person at all costs, because we also know that when you file a complaint against someone that is like that already, then that further enrages them, and it increases the likelihood that they're going to commit a retaliatory act to get you back for you telling on them. You see what I'm saying? And you're doing the right thing because you're protecting yourself, but it's like a catch-22. And a lot of people, you already know this. And so that's basically what occurred. So, and her beef, the irony, here's the sheer irony. So Alexandria is a Caucasian woman. I'm Black. If you didn't know, I'm Black. So her focus was on me. She didn't pursue, getting a, taking any type of legal action against Alexandria. She focused all her energy on me, even though there was another individual, white woman, because Caucasian is white, and that is not inherently a bad word per se. But Alexandria, my friend, was white. That's factual. It's factual. And but she didn't pursue her. And Alexandria was a witness and co-signing the complaint with me. Her name is all over the case, all over the TRO. But her Emily Meister's attacks were instead against me. Okay. So in retaliation, then when I say she went ham on me, the irony of it, because it's Ham's restaurant, that's what she did. So she used all of her corrupt forces, which are definitely stronger than my resources at the time, because I'm not a lawyer at that time. I haven't just graduated. I'm not even in law school at this point. I'm in my PhD. I'm going into my PhD program, because my PhD program started January 2014. And so fast forward, she then effectuates fraud with Judge Carl Fox to enter a gatekeeper order against me. Now, let me back up a little bit, because she first effectuates fraud with Judge Webb to get a gatekeeper order against me in 2013. And I fight it for obvious reasons. This is the first time I've even heard of a gatekeeper order. And it's completely inappropriate. They literally were not even, she was so well connected with the corrupt status quo in Guilford County. Is a very clear record that shows that even just to litigate my stuff, like regular stuff, I was not even being allowed to enter the courthouse, people. I hadn't posed any threat to anybody. They would not even let me in the courthouse. They were like, the rapport that I had before, all that changed. It was like, we don't even know who you are. We're treating you like you are filth. It went from night to day. Sorry, day to night, actually. And so I fought it tooth and nails because it was completely unlawful, obviously, and unconstitutional. You cannot, your basal right to access the courts is inviolate. Inviolate means that it cannot be violated. It's like inalienable rights. They can't be alienated, and they cannot be violated. Okay. When all she had to do was just like, even if you don't like me, okay, fine, whatever. I don't like you either. We can handle this still in a professional manner and just litigate. That's it. Just litigate. Litigate what you think is right. And I'm gonna litigate what I know is right. And then we'll let it decide out. We'll go through the procedure. But all this other stuff, you in the wrong. You have violated the rules of professional conduct under your oath as a licensed attorney. That stuff is prima facie evidence of you doing the wrong damn thing. You violating the law. Prima facie means like it speaks for itself. That's what the Latin means. Okay. So I was able to then get my motion to vacate the gatekeeper heard, and it was heard by Judge Patricia Hennett. Judge Patricia Hennett found that I was right. She goes into great detail in her order as well, where she vacates the gatekeeper order, but she does it in part. So and I could see what she was doing. And this was a Black female judge, an older Black female judge. And I could see what she was doing. And I was like, okay, I'm okay with that. And basically what she was trying to do is, okay, I'm going to try to be objective because I already know their ass is probably going to try to flex on me because I'm the Black woman judge coming in here, and they're going to automatically be like, oh, she's siding with the Black litigant, blah, 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 because that's where Karens go with it. You know what I mean? They immediately draw these type of conclusions, right? All right. So Judge Patricia Hennett, she noted, look, Emily wants Tigers to not have access to the courts, and that's unlawful. We're not doing it. And she's not even been, there have been times where she has not even been allowed to enter the courtroom, and she doesn't pose a threat. So that is completely unlawful. We're not doing that. We're not doing none of that. You can't do that. You can't just say that is the definition of racist white woman tears. Like he looked at me. We know these stories. He looked at me. The Black boy looked at me when he got on the elevator, and I'm scared. And so I want him to die. That's excuse me. That's extreme. Let's say the Black man, let's say on a wild occasion, the Black man actually did somehow, even though we know that not to be the case in the history, right? Right? We know occurrence A did not merit result B. We know that, right? You don't have somebody that looks at you on an elevator who never touched you, even if you're like, well, he brushed up against me. Let's say he did. Let's say he did. It doesn't merit the entire white population nearby this Black population to obliterate or attempt to obliterate the entirety of the Black population where this young Black man accused of brushing against you lived. Occurrence A does not merit result B. It just doesn't. So similarly, she wanted me to not even be allowed to come in the courtroom to file anything. This was her answer to it. Okay. So she realized that I'm not a complete idiot, right? I'm not a complete idiot, whether I had my license to practice or not, or had a degree in law. She realized, oh, this Black knows what she's doing. So then screw that. We're not even going to just defraud the case record. We're not even going to let her into the building to handle her legal affairs. Oh, God. So Judge Patricia Hennett said, no, we're not doing none of that. And she actually scolded her in court. And then she even notes, because she spoke with us both, and she notes that these two people, Meister does not like Tigress, and Tigress does not like Meister, and she could not be any more accurate. And she puts that, it's in the order. Some of you've seen this order because I put it on record, okay? And if you want to see it, just let me know. I'll make sure that it's easily accessible to you, okay? She, referring to Judge Patricia Hennett, she then says, okay, this gatekeeper order can't be enforced the way it is because we can't do the things that we're doing like this. It's completely against the bench book. And that was the first time I learned around that time about the North Carolina Superior Court judge's bench book. And there's a bench book generally for all types of legal tools that are not codified. So there's no statutory chapter. There's no chapter in the North Carolina General Statutes that details the elements for a gatekeeper order. At best, there are sanctions, but they don't go into detail about the gatekeeper order. So the bench book goes into detail about the gatekeeper order. And I've shown you that before. So you can revisit that. And basically, she kept it in place. She said, okay, this gatekeeper order especially can't be in place against McDaniel for other parties, because she's got other cases that she's handling, and she noted on record that these cases she's been handling and they're valid. She said she even notes that I sued Michelle Bailey, the bail bondsman that I've told y'all about, with regards to my Land Rover when I was wrongfully convicted, and sent to prison because I was taken immediately into custody at the conclusion of that trial. I didn't have a chance to get my affairs in order, like they allow the good old boys to do. Get your affairs in order and come back. No, I was immediately taken into custody. So my Land Rover that I used to secure my bail with Michelle Bailey in her company, Infinity Bail Bonds, she destroyed my truck. When my mother went to retrieve my truck, it was completely destroyed. And so I sued her from prison and I won. And Judge Patricia Hennett put that on record as well, okay? So basically she said, okay, now the gatekeeper order, however, I do feel just to be objective, because these two clearly got beef outside of the ham restaurant, because this is morphed into beef. This is pretty much Judge Patricia Hennett's observation. She said, I'm going to leave the gatekeeper order in place, but only minimally so, again, as it relates to Meister. Okay, fine, whatever. Even though I don't agree, because I ain't doing nothing that is not through, if it's not legal procedure, I'm not gonna have no interaction with it. So I don't need nobody to gatekeep me in doing the right thing for procedural sake. I don't need that, but fine, whatever. Okay. So then that they move judges around. Okay. So then Judge Carl Fox enters. This is a Black man, but he was on his deathbed. Some of you remember this man. He evidently had brain cancer. And I was like, okay, so really? And you should have seen the way that it was so in your face obvious. It was so in your face obvious. Some people even went to court with me and they saw it themselves. It was because I got to the point where especially during this time, I didn't want to go into the courthouse without having someone with me as a witness. So I very regularly would go into the courthouse with other people, other community leaders, other figures. if it wasn't Alexandria herself, who was effectually a co-party, right? Excuse me. That being said, they witnessed, as I did, how the white court staff would coddle Judge Carl Fox, and I thought it was just so very interesting, and it was very evident that they had conspired some agreement that he was going to be the willing party to abuse his oath of office and re-enter this gatekeeper order against me at the conclusion of that case. And that's exactly what they did. So our suspicions were accurate. And not only did they re-enter the gatekeeper order, but he amended it effectually and without a hearing. So that's unlawful. You cannot have a hearing, especially on something that would have criminal implications, like criminal punishment. You can't do that without giving that person who would be subject to those criminal punishments, they would be allowed an opportunity to defend themselves, to be heard, hearing rights, right? So an ex parte hearing on a gatekeeper order is unlawful on its face, right? So, but they did that. And basically he re-entered the gatekeeper order, but this time he made it crazy, like super, super crazy, right? And this is where you have the first what's the word I want to use? This is the first record that is started, and it's very clearly intentionally so, to fabricate a record that I have a hugely voluminous history of filing frivolous cases, not winning these cases, and so therefore abusing the judicial system and being this very, very bad person. And then, of course, as you can see, it's very easy because it's very convenient to then add the wrongful felony conviction from 2006 to this stacked or padded, fabricated allegations to make me look like I am loonball, honey. It was a player move. It was a player move. It was well thought out, well conspired, and clearly effective in a lot of regards. Because I've had to fight for my reputation. And still to this day, I still have incidents and situations where I actually have to still prove myself in the midst of their absolute fraud. Okay? So let's go to that. So let's present. And I guess it just had to happen. I'm just going to stay on until I get it done. And then you have it and you'll be able to see it. And it just because I'm at home today and I'm about to get off, but we're going to see. So it's important to get it all out. What I've learned over this time is that my fight has to be public because I can't fight them privately. Y'all, anyone who has been subject to this type of criminal activity, especially by individuals who have the power to conceal their criminal activity, like judges and lawyers or mobsters and drug dealers or whatever they're associated with, when they have the ability to conceal their criminal acts, you have to take your fight public. Otherwise, they can just murder you, destroy you in private, and no one ever knows. So, and I'm not for that life. I'm not for that life. If you gonna come for me, gun-toting or corrupting your oath of office as an attorney, do you see the damage that has been done that through their abuse of their license against me? Imagine if I had not been fighting publicly during this time. Oh, they would have destroyed me completely. Completely. It rolled over to my PhD program. It's just so, it's immeasurably disgusting. And they should be jailed and disbarred. And that is the unmitigated justice that I'm seeking. And I have filed my federal complaint with North Carolina for injunction against them. Injunction is to say, hey, federal court, tell them to stop immediately. And then I'm asking for punitive damages, of course, and sanctions, which means I need to be paid money for everything that they've done, everything they've taken away from me, all of my cases that have been disposed of unlawfully. And we're actually going to get onto that because I've just experienced another case being disposed unlawfully because a lot of people, when I say a lot of people, albeit lay people who have no real real understanding of the law and procedure, right? Civil or criminal procedure. And in addition to that, journalists, you know what I mean? Who love sensational topics, or they like ambulance chasers, if you will, and running to a story and just writing whatever will get them their papers sold and then some recognition and hopefully, I guess, like some type of journalist award, which is completely unethical, and it's even against their oath of journalism. And then you have the most extreme, which are other lawyers and judges who are part of the good old boy system. And so they keep the lie going. They may not have, they try to like tout that, oh, my hands are clean. No, your hands are not clean. You have kept perpetuating this story by not speaking out on just how rogue and fraudulent this conduct is demonstrably. Like, it's very clearly, evidently so. And I've also explained to you as well that the judicial canons and the rules of professional conduct for the North Carolina bar very clearly stipulate that if an attorney, a licensed attorney, or a judge is aware of fraudulent conduct, corrupt conduct by a fellow judge or attorney, that they have a duty to report that and not conceal it. Yeah. Okay. So basically, what I'm getting at, the extreme issue on this in this matter is that there have been judges and attorneys who have basically fueled this fire with their own libelous statements. Like the most recent was the Democratic Party president. Hold on, let me find his name so we speak about him specifically, because I sent them a letter to cease and desist, and if you recall, I posted that letter on my political platform. I sent it to him by email, and then I sent it to him by certified mail. Hold on. Trying to think. I sent it from my. Hold on. Give me 1 second. I'm looking for it. Democratic Party. Hold on. Just give me 1 second, please. I send a cease and desist because it's around the time that my uncle passed away. My uncle Elroy, which was my mother's last surviving sibling, passed away, and you heard me refer to it in the fall. And I should have known because he was actually rude, very rude, in his response when I acknowledged that they were Drew. There we go. Yeah. Is very, very rude. And I don't have to just say that. I'm going to show you. Because I asked, they had a deadline for the questionnaire. And I had already advised that I had a death in the family, and one of the other leadership or the other, executive officers or whatever on the board with the Democratic Party had responded, giving me additional time, and it was in the feed. So it wasn't like, and in his own words, he's self-admitted. He's an attorney. He's a licensed attorney, and he knows a thing or two because he was very matter of fact as it relates to the statement I'm about to make here. So it is illogical for him to have been privy to the feed, our email feed about the death in my family, and the other board member responding and giving me more time to complete the questionnaire. It's unlikely that he didn't see that. But he then responded with his ass on his shoulder saying, you don't have more time, basically. Like, you have until now. And I had literally just told him, I'm literally at the funeral right now. But I'm responding because I understand, I understand that this is important, but I'm at the funeral right now. And most people, your average person with any good sense would say that was disrespectful. And your average person would be like, I'm not going to respond because I'm at a funeral. I'll get at you when I get at you. And generally, societally, that would have been completely acceptable and completely justifiable. But yeah, so let me get to it. Yeah, and so this shows you, literally, I'm at the funeral now. On yesterday, I was told the survey would be open until midnight tonight. And you see where he says, so we won't be able to give any further extensions. You're not giving me any further extensions. I was already told that it would be open until later that night. We'll give you until 5 o'clock. Look at the time frame. Let me see if I can pull up the time frame on that. That was 12/28. I was in Graham. My uncle Elroy he lived in Graham for the majority of his life, for his adult life. I was in Graham. Okay. At a funeral. Okay. So yeah, but his name is Drew Cromer. And so at this event, which was only a few days thereafter in October, he hits us with some unexpected questions. And the question that he asked from me is why I filed 172 cases in 72 counties of North Carolina. And I responded, and I didn't know he was an attorney at that point, right? So I responded, well, as a lawyer, and anyone in the audience who is a lawyer or familiar with legal procedure, even minimally, they understand that to achieve that would be quite unlikely, especially over the time frame that they suggest had occurred, and especially for one person. Like, I'm doing my absolute best right now to handle 10 cases, and not all of these cases were necessarily filed by me. I'm having to like litigate regardless, right? So I would say, I think it's like 3 cases were not initiated by me, but of course I'm having to represent myself. And then 10 cases were initiated by me, and of course I'm having to prosecute my claims. 13 cases, this is the most that, this is the largest amount of cases I have handled at any, time together like that. But they're suggesting to you that I can handle 172 cases in 72 different counties. The 10 cases that I have now, all of them are in Wake County. The three cases that were not initiated by me were initiated in Mecklenburg County. And what makes them more convenient and more reasonable to handle like this is because I can do it online with the remote or e-filing now. So the notion is absurd. It's illogical. It's imbecilic, in fact, for anyone to, especially someone that is aware of how legal procedure is and what is entailed to actually prosecute claims. It's near impossible for just one person to handle 172 cases like that, and in 72 different counties of North Carolina, which were not on the e-filing system during this time. Because remember, e-filing didn't come until after the pandemic. So what you all should be doing is actually laughing at them in their face, because it's literally straightly a stupid allegation. It's like, it's not even plausible. But his response in front of the attending Democratic Party members was that I am a licensed attorney and I know exactly what it takes, and I know that this could happen. And I was thinking, well, wow, so you just basically publicly admitted that you're a complete idiot, and otherwise you're completely fraudulent. You're like, you're ready to go along, get along with the go along. You are part of the good old boy system. There's only two things that you're affirming. It's either you stupid as hell, or you know that this is completely impossible or implausible, but you don't care because you know that people will believe you over me because you're a white man who has your license to practice law already. Got it. Yeah, so I drafted him a cease and desist. But basically, ultimately, kind of going full circle, because I was just talking about how the extreme negative impacts of Emily Meister's drafting the gatekeeper order in the way that they did with Judge Carl Fox. It has had these long-lasting impacts on my life and my litigative history. Okay. All right. That being said, so this 72 counties actually comes from her first. And then it was copycatted fraudulently by Richard Huffman to help Michelle Meister commit fraud to evade the levy that had been placed on her bank account to pay the judgment that was awarded to me of $5,000 for the damages that she did to my Land Rover while it was in her possession as bail bondsman. This is all, are y'all getting it? You see how it's a web there. It's a web of fraud and public corruption from them. Very tightly wound, okay? So basically, Emily Meister actually the gatekeeper order or the gatekeeper bench book has several, like it's like 10, I want to say like 10 specifications. This is what the gatekeeper order cannot do. Amongst those is the gatekeeper order must be narrowly tailored in both the county that is specific to the the reasons why the gatekeeper order was put in place, and it must be narrowly tailored to parties that it would involve, right? So pretty much like what Judge Patricia Hanna had already said, like you can't have a gatekeeper order against Tigress that restricts her filings against everybody and anybody, because it would be unlawfully restrictive in so many ways. Like say if my boyfriend was kicking my ass, based on this gatekeeper order, I have to get permission from a criminal magistrate before my criminal complaint can be filed. That could very, very, very reasonably be very dangerous for me. If I'm dealing with someone that actually poses a imminent threat, fatal threat to me, or even just physical harm, significant physical harm, having that gatekeeper order can be very bad, especially considering that Emily Meister, Keith Black, which is her team, and I can't think of the other girl's name. I want to say it was Amanda something. I'm not sure, but or no, I want to say it was started with a J. But nonetheless, because they are not only they have this on record, but they are conspiring behind the scenes, telling people, yeah, treat her like shit. When you see this name, treat her like shit. Treat her like shit. And bring up the felony conviction. Treat her like shit. They've consistently done it. There have been people that have gone with me to court and like they're like, what in the world? They can't say that. They can't do that. And they've done it consistently since 2013. It's 10 years. 10 years. And I actually saw a quote one time that sometimes it takes a decade for the truth to come out. It was something to that effect, but it burst out like a geyser at that point because it can't be contained anymore. And that's what's happening right now. Okay. So basically, also with it being narrowly tailored, right? It can only be specific to the county. So this case between me and Meister, or between me and Hams, then between me and Meister, right, was specific and limited to Guilford County. Like I didn't file anything else in any other county against Emily Meister. So there is absolutely no justification for the gatekeeper order to be in any other county. I don't go to any other counties. There's no history. I could see also it could be minimally argued if I had a history of filing in other counties where Meister could say, okay, hey, Judge, I need this gatekeeper order to be in all the counties where she has filed before, because there's a history of her filing in those counties. And I want to make sure she doesn't file anything against me in those counties. That can make sense. But it can't make sense for you to file. So basically what she did is unlawfully, she then she perpetrated the registration of this gatekeeper order behind the scenes because it's unlawful for her to put it on actual case record because there's no case in any of these counties. You see what I'm saying? There's no active case for her to put this gatekeeper order in. So what she did is she effectually registered it so it would just be on records. Like you have the register of deeds. Well, there's just a registration, right? These are CR records, not CVR. Or you see what I'm saying? They're just CR records. And it's just literally a record, right? So you can think of it like a property record or whatever, or marriage record or death record. So it's just records. So she perpetrated the registration of this gatekeeper order in evidently 100 counties. She evidently sent it out because there's a note, a handwritten note on a copy of the pleading that I never saw. I never saw until recently. And it's a handwritten note that says, send this out to all 100 counties. And it was authorized by Judge Carl Fox. So that in and of itself was also completely unlawful. And it was concealed because I hadn't seen it. It was something that they did behind the scenes, showing further deceit, intended malice and deceit, right? Okay. So this is where so when she perpetrated this registration in all these counties, then my name, when you search my name in the, in the case records, when you were doing it in the computer, up would pop all of these CR records in all of these counties in North Carolina. And evidently 28 of the counties, or 27, because 72, I can't even count right now. 78. 28. 72 plus, y'all help me. Yeah, 72 plus 28 is 100. There are 100 counties in North Carolina. And I only learned that through my PhD program, because some of you know that my study was on naturally occurring wetlands in central North Carolina. And so in so doing, I had to identify, I had to set the parameters for central North Carolina. It wasn't a preset. Like I didn't just take someone else's standardization of what central North Carolina was. And I had to decide which counties I was including for my study, right? That being said, I learned inadvertently, like in the process, that there are 100 counties, right? So evidently 28 of these counties not ever registered it as she intended it to. And if this goes back to when around the same time that my uncle passed away, when I had the rental, I went ahead and took advantage of the fact that I had the rental. And it was a Tesla, so it doesn't, it didn't take gas money or whatever. I went ahead and took full advantage, and I couldn't drive to every county because there's 72 counties, but I drove to 2 different counties, Buncombe, which is Asheville. That was my first time learning that. I didn't know Buncombe County was Asheville. I had no clue. And then Hartford, I think. I went to Hartford. That was very enlightening in Hartford, because they were like, this is crazy. They were very clear about this is crazy and odd and unusual and strange as hell. Buncombe stuck out to me. And I just went on intuition, because there was nothing that like signified like, hey, this is a red flag. The only red flag that I saw, I would say conversely, the only red flag that I saw was that one of them was filed by someone with the last name Meister. Oh God, I can't remember. Someone with the last name Meister, but it wasn't Emily Meister. So I was like, interesting. Maybe that's a relative. And I definitely want to check that out, because I don't have any, like, it would be completely inappropriate for someone to register a gatekeeper order against a person if they're not a party to the case. You see what I'm saying? Like, you're not the victim, quote unquote. You're not the complainant. So why are you filing something against me? Why you got my name in your mouth, pretty much. You know what I mean? So that's why I went to Buncombe. And they confirmed that evidently she came in and see these courthouses weren't necessarily like on her team, quote unquote. She was concealing. You got to understand. And I would imagine in some places she had their full agreement to conspire her fraud. But in other places, in other counties, she evidently had this person, someone who evidently was related to her because they have the same last name. We infer that, right? She said, hey, take this over here and register this because I can't get there. It's easier for you. Take this over here, right? And generally, the standard is for the courthouse, the clerk staff, to just file whatever you submit for filing, unless it's just completely egregious and ridiculous, right? And so that's what occurred there. And they confirmed that, and what that person didn't realize is that her name would actually go on the record as the person recording the gatekeeper order. So that's one of the the occurrences that evidences the deceit and the fraud. You see what I mean? The underhanded nature of it. Because why are you, it's inappropriate to have your cousin take something to file on your behalf. It is. It is. Something like that, it is. Like, yeah, you can, yeah, is it a statutory violation to have somebody file something for you? No. But is it underhanded and ethical? Hell yeah. Hell yeah. All right, so fast forward, because look, y'all getting it all. It's there. You're going to have it. It's there. All right, so now this is going to make sense when you see this email feed. All right, let's go to it. That's all right. So in that same time frame, I went ahead, learning all this new information, I went ahead and filed a motion to vacate the gatekeeper order in Guilford County. And I filed a motion for sanctions against Emily Meister for her knowing acts of fraud in perpetrating the registration of this gatekeeper order in a concealed fashion in 72 counties of North Carolina, right? And also keep in mind that, now let me explain this to you really quickly so it all comes together. The copycat gatekeeper order, how was it copycat? Because what Richard Huffman did is he then said, I'm going to reference what Meister said to get a gatekeeper order against her in this case too. And pretty much from this point on, this is exactly what they've been doing. So it's like, hey, this is how we've been winning our cases against her. Just put this gatekeeper order on her and say, and use this information to get the gatekeeper order. Works every time. Everybody's on board. Don't worry. Everybody's on board. And that's exactly what they've been doing. So, of course, I filed a motion to have that gatekeeper order vacated, which means to have it removed altogether. And then I asked the court to award me damages and, place sanctions against her. Okay. All right. So I hadn't heard anything back. I've called, I've asked for an email address. I called one time and they were very rude to me, Roberta. And she was in the judge's chambers and she was like, yeah, we got it. And we'll get in contact when we do. Okay, well, the gatekeeper order requires that I submit my pleadings to the judges, whatever judge would be appropriate. So if it's a superior court action, then it goes to the chief superior court judge of the county. If it's district, then it goes to the chief district court judge. You see what I'm saying? And there you have it. And if there's a chief magistrate, then it goes to the chief magistrate for small claims. Otherwise, it goes to the magistrate. Okay. Same thing for the criminal magistrate, as I've already spoken about. Okay. So this is a superior court case, hence the CVS. So I submitted it to the judge's chambers for the superior court, right? To be reviewed by the chief superior court judge to give me an administrative order to approve or deny the filing. Now, keep in mind that this is not something that requires a hearing, because this is just a straightforward review. If a gatekeeper order is proper, then the only way the gatekeeper order can be used is to review whatever the person who is subject to the gatekeeper order submits to the court to make sure that it, at the very least, follows legal procedure. And then, like, for instance, that they haven't filed something that's just like a whole bunch of profane language and inappropriateness and all that kind of stuff, right? And I've not ever filed anything like that. So I don't have any history like that. So ironically, that being said, everything that I have filed has always been approved. And that has pissed them off. It just gets, it gets wilder and wilder. It's pissed them off because they're like, well, she's not filing nothing wrong. So how do we keep her out of the courts? Because we want to win cases against her, and we want to do it, in a bad way. We want to maliciously do it. Because she is filing properly, we have no choice but to approve it, and then she's still winning. So what they started doing is, and that's what I've argued in my federal complaint, they started saying, okay, well, let's just ignore her pleadings and let's delay her pleadings. And if you know anything about civil procedure, you have a time frame where you have to submit things. Sometimes it's 30 days. Sometimes it's as few days as 10 days, like notice of appeal in some regards, right? Or a response. Sometimes you have 14 days. And so they would basically not even review my pleading during that time frame. And then I would continually, follow up and find out, okay, like, has it been approved? Has it been approved? So I can go ahead and get it on court record. So then they get it approved and I take it down to the courthouse, and then the clerk's office would be like, well, we need a administrative order showing that it's been approved. The judges would be like, well, no, I'm not providing you any administrative orders because I already said it was approved in the email. I take the email down to the clerk's office. The clerks will say, nope, sorry, this is not sufficient. We need something else. So then by the time that I would actually get an actual order, in one case, I didn't get any order because Lisa Bell from 2018 to like 2020, she refused. She put it in writing. I'm not drafting any orders for you. I'm not drafting any administrative orders approving or denying whether you can file something. If I give it back to you, she literally said it. If I tell you to come pick it up, then you're allowed to file it. And that doesn't even make any sense either, because you're in the court of law. You're in the legal capacity, so you understand why a record would be appropriate. And considering the nature of everything, then it would be highly appropriate to then have an administrative order on record approving or denying whether or not I can file something. So there's no confusion. So that means that it was bad enforcement of the gatekeeper order. You see what I'm saying? And that became their angle. Like, this is the only way we can win against her because she actually is a good litigant. She actually isn't doing anything wrong, okay? So all this is right now is a motion to vacate there needs to be an administrative order saying you are approved or denied filing this motion to vacate. And if we're applying the law objectively and fairly, he can't, whoever this judge is, the chief superior court judge for Guilford County, they cannot deny me filing the motion to vacate the gatekeeper order, because the bench book also requires that there is an opportunity to modify or remove the gatekeeper order altogether. So there is no good justification for denying me just the filing of the gatekeeper order. Okay, that being said, now you have understanding. Hopefully this all makes sense. If you ever have any questions, please feel free to comment and I will answer your questions. All right. So it says, good morning, Mr. McDaniel. Just randomly, please understand, randomly, because I'm trying to figure out what's going on with my motion, what the deal. January 2nd. I get a random email. I don't know who Brittany Robbins is at all. I have absolutely no clue. And I don't even know who this Amanda Laster. I think I referred to her, but the person that was in court with Meister was someone else. It's in the court record. If you see it before me, there you have it. I'm not gonna look it up right now because I'm trying to at least get off of here by 4 o'clock, because it'll be a 3-hour broadcast. And some of y'all love these 3-hour broadcasts, okay? But as you can tell, I'm deteriorating here, so I need to go ahead and get off. But I want to go ahead and get this done because I'm effectually fighting for my life. I'm fighting for my character. I'm fighting for my reputation. I'm fighting for my academia. I'm fighting for my profession, my livelihood, all the things. All the things. All right, so I just get this random email from her that says, and this is completely with the shits. Good morning, Mr. McDaniel and Miss Laster. Happy New Year. Like, let me keep going. And I hope you are both well. Like, what? Who are you? Who are you? I wanted to provide you all with a quick update. Interesting. Because remember, it's my motion. It's my motion. It's okay. Let me just keep reading. With a quick update as to Ms. McDaniel's request and the above reference matter to lift the current gatekeeper order. Judge Wood still plans to hear this matter tomorrow morning at 9:30. Okay, I'm gonna say this one more time. I haven't received an email. I haven't received any letter by mail, and I drafted a cover letter. I am those who know me, again, I'm not called Queen and Get Her Done because I be with Queen and Get Her Foolishness, okay? There was no requirement for me to draft a cover letter with my submissions. But because I keep very, very concise records, that's what I did. And I have a file for every cover letter I have ever sent to the courthouse. And I attach a cover letter to every submission that I've made to the courthouse, period. And in that cover letter, it has my address. Some of you also know when you draft a pleading, you have a certificate of service and your address is clear, or it's clear in that. Normally when you sign your pleading, you sign with your name, you identify yourself as plaintiff or defendant or whatever, or counterclaimant, whatever. And then you sign it with the date and you have your address. And that's what it's there. It's there. Okay. So I've received nothing from the courthouse. Okay. So Judge Wood still plans to hear this matter tomorrow morning at 9:30 a.m. So this means that they have scheduled this without even conferring with me. And that's completely unlawful. It's my motion. You must confer with the party, the moving party, and the court must take into consideration the moving party's availability to even attend court in the first place. A motion cannot be scheduled by only conferring with the defendants or only conferring with a plaintiff. Both parties there has to at least be an attempt to contact, and there was no attempt. So this is my first time learning of this. Some of you know that my rover is, my suspension is broke. And I ain't got no money to be paying for no rental to go to Guilford County. They know I live in Charlotte. Ain't nobody confused about that. So you tell me that there's going to be a hearing tomorrow morning. Look at this. She sent this at 11:40, midday, 11:40 on January 2nd, the day after the holiday. She don't even know if I'm out of town. I could have been out of town for the holidays. The hearing will now be moved to courtroom 3G. Really? Should you have any questions, please let me know and I'll be happy to help any way I am able. Wow, y'all. This is my response. Because I see it an hour later, as you see. This cannot be heard in my absence. This is the first time I'm even receiving any acknowledgement scheduling for my motion. This is exceptionally unlawful. This hearing, because at this point, I'm trying to, the way that she's saying it, because she's saying that there's a hearing. And you'll see what I mean when we get to the bottom of this feed. But based on her email and based on the civil procedure, it is safely inferred that she's referring to a hearing on my motion to vacate that hasn't even been approved for filing yet. It hasn't even been filed before the court. So this is me. This is the first time I'm even receiving any acknowledgement scheduling for my motion. This is exceptionally unlawful. This hearing must be postponed and properly scheduled with statutorily enjoined notice to me, the moving party. How is it even scheduled or scheduled? That's a typo, without conferring with me, the moving party. Okay. Also keep in mind, which you'll also learn later in the feed, I have been seen by the doctor on December 23rd and December 30th for exacerbated asthma. Okay. Okay. All right. Okay. All right. So, where are we at? So then I resend it because I wanted to make sure to include Emily Meister. I find her email address on the North Carolina Bar website. And I make sure, again, I say this cannot be heard in my absence. This is the first time I'm even receiving any acknowledgement. And then I make it clear I reside in Charlotte, about which Guilford County court officials and staff have been sufficiently informed, which also appears conspicuously within my impending motion to vacate the gatekeeper. My vehicle has been in disrepair and thus undrivable since last summer, and I have rented vehicles for commuting purposes when I could afford to and where search was necessary. My last visit to Greensboro was for funeral arrangements, and while having the rental, I handled business at the courthouse, including submission of my impending motion. I do not have transportation to Greensboro for tomorrow, nor would such be somehow reasonably required of me due to the one-day notice you've given me. Even when I have called to inquire about the status and proper handling of my submitted motion, I was told by Roberta that the court would contact me. I have checked my mail and have received no notice of hearing nor any correspondence from the court even acknowledging my submitted motion. The hearing on my motion must be postponed and properly scheduled with consideration of my availability, etc., and with statutorily enjoined notice to me, the moving party. Again, I go back to how was it even scheduled without conferring with me, the moving party? I've CC'd Meister using the email address from the North Carolina Bar Director, which also notably shows that Richard Black, the other subject attorney, is deceased. I recalled him as Richard Black, and that's probably because, remember, Richard Huffman, you'll see later, he evidently is Keith Black, and evidently Meister tells him, this lady thinks you're dead, so you need to answer up. Okay, so I'm expecting the next email to confirm that this hearing has been postponed, continue for proper scheduling, okay? So, and you see, I've blocked her at this point, but we're gonna get to that. So good afternoon, Ms. McDaniel. These salutations are completely with the shits, I hope you are well. What? I sent an email back in November. Lies. Y'all already know how I roll. I'm checking everything. I'm getting everything. I sent an email back in November stating that Judge Wood was going to schedule this hearing. I am trying to go through my emails now to locate the same. You're a lie. My name is Tigress McDaniel. My name is Tigress McDaniel. It comes up. You see this? It comes up. I don't have no nickname listed with my email address. You see this? You see that I'm circling it. For prosecution only, if you're searching your email, all you have to do is put in for prosecution only or Tigress McDaniel, and it will pop right up. It ain't gonna be, there's no way it will be mistaken for nothing else in your feed. And we know she lying because it's implied that, honey, why didn't you never got a response from me? Why do you think that is? If you really sent me an email and I didn't respond and you scheduling shit, you can't do that. That's not how the law works. That's not how the law works at all. Okay. So then she says, I guess I hadn't responded yet because I thought I had responded immediately, but I guess, okay. So then it says, Mr. McDaniel, I have spoken to Judge Wood and informed him you did not receive my previous correspondence about this hearing. That's such a lie. He is trying to get your matter addressed as timely as he is able while addressing his regularly scheduled court sessions. He has suggested that he can reschedule the hearing to be held in person on Thursday, January 4th. Is she not hearing me? Like, what? Or he is willing to proceed with the hearing tomorrow as scheduled. What? But move the hearing to be heard via WebEx, which would eliminate your need to find transportation to Greensboro. I am literally sick on January 2nd. I'm literally sick. Okay. Would either of those options work for you? Like, what? So my response is, because I'm completely outdone. Brittany, that is a falsehood and you know it. I have received nothing from your office nor from any other staff department of the Guilford County Courthouse. And you don't just dictate to me a date for a hearing. Whether a gatekeeper order is in effect or not, any party to an action is lawfully considered and consulted with scheduling hearings. And in this case, such is inarguably so because I'm the moving party, the party to be heard during the hearing. So it is wholly illogical that you or any other court staff or official would unilaterally schedule a hearing on my motion without conferring with me regarding my availability nor noticing me the decided date of the hearing. This hearing must be continued and scheduled proper with due consideration of me. If what you say is true, you don't find it odd that you got no response from me? And where is the formal notice of hearing, which is also statutorily required? There's no formal notice of hearing. Like, what are you talking about, lady? Fact remains, this was not handled lawfully, and I cannot be there on tomorrow. And nor is it appropriate for me to have a remote hearing like that either, because I am completely sick, and thus I cannot prepare for litigating. And if y'all know anything about having to represent yourself in court or defend yourself or argue anything in court, you need to be prepared, because otherwise they will run you through, honey. They will run you through. I'm not prepared for tomorrow morning. You coughing and carrying on, half breathing, no, on prednisone and lidocaine to calm the inflammation in my throat, no. Talking, being required to talk, I'm still drinking. You hear me coughing and carrying on right now and drinking water. How would you presume that I was feeling at the day that I get this email? This hearing must be continued and properly scheduled with statutorily enjoying consideration of me, the moving party. A remote hearing addresses the commute and transportation issue, but I'm not available on the 4th. 2-day notice of hearing is equally unlawful. I am available on the 3rd or last week of January, but not available on January 17th. And this is all accurate. So remember, I've already got the January 17th remote hearing, because I had to ask for a remote hearing for the North Carolina bar. They unilaterally scheduled that. Okay. So I've been in constant contact with them, and she has been in constant contact with me. So that's what I was expecting. And I made it clear, because I was like, okay, I also know that I have the new PhD program, remember, that I've applied to. So I don't know what's going to be expected. I know the start date was January 10th. The last day to register is January 17th. There are a lot of working parts here. Okay. So then she says, thank you for your response. Per Judge Wood, if you are not available this week, he will reschedule the hearing for a later date. I will be in touch in the near future as to when he is available to reschedule the hearing. Okay. Okay. Thank you again. All right. To further clarify, looking at the calendar again and make sure I'm available the 4th or 5th week of January, the weeks beginning January 22nd or the 29th. Keep this in mind, what I've said. Okay. This is all in the same feed, and it's including everybody. Everybody sees this. But those dates are also subject to confirmation from my academic advisor, Dean. I cannot confirm my availability until I receive confirmation from them. And I'm still dealing with that. Okay. And I have proof of that. Otherwise, I will have availability in February. But again, I must confer with my academic advisor, Dean. I'm expecting to hear back by the end of the week, and then I can update you at that time. Okay. She responds, I will be back in touch as soon as I am able, as that will depend on when I receive a scheduling update from Judge Wood. So she responds to my email, giving her clear dates when I am available and not available. His availability will be determined based on his scheduled court session. Okay. All right. None of this is lawful. Your conduct will be reported and included in my federal complaint for injunction. And it is. And what is Judge Wood's position with the Guilford County District? Based on your conduct, it is demonstrably likely that he is also a willing co-conspirator. I'll need to verify his affiliations and determine whether or not he is fit to hear my motion with impartiality. Again, because otherwise he would be subject to recusal. Again, regarding my availability and vetting of this judge, I'll formally notice the court, both the state tribunal and the prevailing federal court. I shall not tolerate your continued corruption, and I won't. You all should be ashamed. This is Brittany. Remember, everybody's still in this feed. Now at this point, you see that Keith, that's who he is, not Richard Black, but Keith Black. He's in there as well. Good morning, all. I hope this email finds you well. This stuff is so much with the shits. And safe after yesterday's storm. Is she serious? That's like psychopathic. Okay. Judge Wood's court schedule for next week will allow him to return for a hearing in this matter late in the week. You see, this is 2 days, remember, so there was no communication. So we got 10 days, January 2nd. I get an email 2 days ago saying that therefore he is scheduling a hearing for this case on Friday, January 19th in the Greensboro courthouse. I will confirm with you all which courtroom this hearing will take place in by the end of business Friday, January 12th. Is she serious? Is she? She can't be serious. Please confirm receipt of this email. Like, what? Then these fools have the nerve to answer up. Like, understand, this is them. Thank you for confirming. This is me. Brittany, this is not how this works. I am not available on Friday the 19th, and I'm not. You have no privy, nor does the court, to unilaterally schedule a party's motion without regard to their availability. So no, the hearing will not be held on January 19th because such is wholly unlawful. I just gave you my availability. And it's a gross violation of my constitutional rights to due process inherent there too. My availability begins after February 8th. So you can give me dates that are available after that time. However, still, I'll make the calendar request, which is in full accordance with local rules and civil procedure, and then I'll confer with the defendants and their counsel regarding the same. Again, a hearing on review of my pleading under the gatekeeper order, because at this point she says, wait, because there's something where she says, oh, let me clarify. Hold on. Where is it? Let me make sure we get there. Because she says that. She said, oh, wait, let me clarify. Actually, he's not hearing the motion to vacate, and he's actually just hearing, he just wants to have the discussion on record as to whether or not he should approve your pleading. Hold on, let me get to that. Because that's important. I think it's appearing out of order. I think we're going to see it here in a second. Yeah, I hope you're well. Judge Wood believes it to be most appropriate to handle the discussion on record in open court to determine if you should be granted approval to file your motion, and he is trying to do so as soon as possible. You guys, this is so unlawful. Again, therefore, per Judge Wood, the hearing to determine if your motion to vacate the gatekeeper order will be filed with the clerk will proceed on January 19th at 9:30. Again, what? And then if allowed, the hearing on the motion itself will immediately follow. What? What? Y'all. On a day when I cannot be there, I've made it very clear. Now keep in mind, because they hadn't done anything, I filed this federal complaint for injunction, and I believe this is what they're trying to weasel their way out of, and I'm not sure what their aim is. I have no clue. I also don't want to be in this courthouse by myself. So I need to go when someone also is available to be there with me for safety reasons, because they can also very easily say, well, you're acting out, so we're holding you in contempt of court. And I won't have anybody to witness that. And I could be hemmed up in Guilford County, because they can literally put you in jail up to 30 days for contempt of court. And then you start. No, I can't do that. I have a son. Like, I live in Charlotte. Like, I can't do any of this. No, my availability hasn't somehow changed, because Judge Wood believes it to be most appropriate to handle the discussion on record in open court. None of this is lawful. The hearing cannot be lawfully held because I cannot attend on that day that you unilaterally dictated to me on today. So no, the hearing will not be held. My presence cannot be required because there is a lawful precedence for such dictated hearing on review of my submitted pleading. This is not how this works, and this is being added to my federal complaint against you all. Emily Meister nor Keith Black. So the review of my pleading is not up for argument by the defendants. That's not how that goes. The review of my pleading under gatekeeper rules is just something that the judge does. They do that behind the scenes unilaterally. It is not something that Emily Meister nor Keith Black can give their opinion on. Their opinion doesn't matter. If my pleading is conforms with law, it needs to be approved and filed, and that's it. Okay. So the assertion of the same is inherently violative to my constitutional rights to due process. You all have remained corrupt, so I'm not wasting my time attempting to reason and demand that you abide by the law to which you all adjourn. I will not be there, nor can any, and I mean enjoined, nor can any hearing as you and Judge Ward purport can be lawfully held. Also see attached. I didn't assert it because the hearing is improper in its entirety, but I can't be present regardless because I have COVID symptoms. And despite testing negative twice, I've been admitted to the ER twice in the last 2 weeks and have a respiratory virus and have taken prescription meds and recovering. I can't be there physically because I don't have transportation there. I can't be there remotely because I'm recovering. And most markedly, I won't be there because it is not a lawfully scheduled hearing, nor is the hearing procedurally proper. It's all hogwash and demonstrable judicial fraud and public corruption, and none of you have any shame. But you should all be held liable directly. Tigress McDaniel, Juris Doctor. And then, of course, you have it on record. It doesn't show any, personal information that, is confidential. Then she attaches immediately, doesn't respond to anything I'm saying. This is why it's psychopathic. Attached, please find the file state notice of hearing for next week's hearing. Is she sick? And you'll notice here, find this. This also is very telling. Look at this, very telling. Via email. Like it's unlawful. I won't be there. And this is also going into the federal complaint directly. And my mentor is confirmed. Yes, this is your notice that I'm blocking you from email communication. There is no law which mandates that I permit email communications. You can correspond by mail and only in full accordance with the law. Any unlawful correspondence will be rejected and filed as an exhibit in my federal complaint against you all. I'm not going there. It's dangerous for me to go there by myself based on how they're moving, because they're moving very suspiciously, very demonstrably, fraudulently, and psychopathically. Like she's on some, I know that we're fucking you over, but hi, how was your day? I hope you're well. Hope you stayed out of the storm. Like that's on some Key and Peele, like his movie Us. Like I'm good. Do what you're gonna do, and we just gonna hem you up in federal court. That's federal court's gonna have to get you, because there's not, like, I don't have time for this. I don't have the time to be sitting in somebody's jail over your fraud. I'm not doing it. I'm not doing it. And I'm sick. I go there. They're not going. They go. And I don't want to say this like a verb. So I'm not. Yeah, we've seen way too many of our beautiful Black people be in the custody of police while they were experiencing medical crises. And that is a very convenient opportunity to just let them die. And I'm not dying in a Guilford County jail at the hand of Meister and Black. No, that will not be the end of my story. It won't be the end of my story. And there you have it. And there are no criminal implications. So there's absolutely no reason for me to, like, I won't be there. And we're stopping all this email communication because you're using it. You're conveniently usurping this method to effectuate your fraud. And we're going to stop that. Everything you send to me needs to be by certified mail or mail. And that's it. That's it. We're done. And that's it. But I wanted to get to, did she put it? Where she says, oh, let me clear up the confusion. He actually just wants to where is it? He just wants to have the hearing on whether or not your motion can be filed. What? No. 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 Like, no. I can't say enough no's to signify. Like, I don't have enough no's. I need more. I can't find it, but it's in there. Let me see if let me clear it up. Let me clear it up. It's in there. Let's see, Brittany. Let's see if I pull that up, and then because we're already like we over the time. Yeah, so then he sends an email. So I think it's in this feed. It's separate. Yeah, here we go. Okay, I'm glad I was able to find it so it'll be on record. So the reason why I couldn't find it is because she started responding to Keith Black's emails, okay? All right, I would like to clarify that Judge Wood plans to hold a hearing to determine if there are legal grounds to allow your motion to be filed. As of this date, the documents previously delivered to Chambers by Ms. McDaniel remain in our office unfiled. It's a motion to vacate. It's review under the gatekeeper order is not adjudication on the merits. You don't adjudicate, and all that means is you're not going to get into the details of it. The review is just to say, is this filing something that is legally, procedurally appropriate and otherwise not profane or frivolous on its face. And that review does not require, like, it's straightforward because it's a motion to vacate. And that's exactly what I said. And I said that is unlawful as well. The gatekeeper order, even if lawful, is not for the review of the likelihood of the court ruling in my favor on legal grounds asserted or applicable inherent. The gatekeeper review is exclusively for basal review of the pleading, generally against legal procedure or frivolity. There can be no frivolity in my motion to vacate because North Carolina law and the North Carolina Superior Court Judges Bench Book mandates that a gatekeeper must include an opportunity for modification. Therefore, there is nothing for Judge Wood to consider because my motion is anchored by an inviolate right under both North Carolina law and the Bench Book, and most notably, constitutionally inviolate rights to due process, which prohibit a gatekeeper or against any party indefinitely or without modification. In this case, the gatekeeper order was corruptly effectuated at its onset and has remained unlawfully unchecked and unmodified, unresolved for way too long. Your response raises more issues than resolves, and all of this record will be added to my federal complaint for injunction and punitive damages against you all. Then here they are again with, please just let us know when you have a court date. Like, what? So y'all gonna go in the court and this is so unlawful. Then I respond, even more so, neither Emily nor Keith enjoy hearing rights regarding my submission, review and approval or denial of the filing of my submitted pleadings. Neither is a formal hearing required for the court or the judge to review my pleading and provide me with an administrative order approving or denying filing of my submitted pleadings, respectively. Neither Keith's nor Emily's input, opinion, legal arguments, or material, and in fact are wholly moot for the review step stipulated in the gatekeeper order. You are also corrupt, unqualified, and rogue in your deceit. It is immeasurably disgraceful and disgusting. Brittany, the review of my pleading requires no such hearing. Guilford County has not ever held one before such purpose, and they haven't. Anytime I submit something, after they review it, I get a administrative order saying it's approved for filing because nothing's been denied. Albeit corruptly minimally, has straightly provided me with an administrative order approving my pleading for filing. That's all that needs to occur at this juncture. If Keith and Emily have told you otherwise, their deceit and corruption remains it's a typo, as out of control as I've already stated in Liberty. All right, so that's the update in that regard. Like I said, I've got the federal complaint right now. But let me show you this real quick because I'm gonna tell you, I don't know. Looks like they're with the shits too. So I'm the time frames are so coincidental because I filed my complaint for injunction in October, I filed it in November. Yeah, in November before the holiday. Okay. I am just receiving word or case activity on this case. I'm just receiving the case number, January 9th. It's just so coincidental. Like it's just odd. And this is where it gets to the fraud that I discovered in the MAA case that actually will be evidence that I'll enter on my federal complaint, because what they're trying to do is cover their steps. They're trying to show, oh, no, we haven't done anything wrong. See, we haven't done anything wrong. See, she's a liar. She's a liar. But they got. They played themselves. Okay. So look at this. So I just get this and I'll show proof that this is the first time I'm receiving this. You see this? This is McDaniel versus State of North Carolina, right? So we're going to just search for this. This is the first email. There's no other email before that. I just received these. The irony of the time frame that I get an email from her on January 10th. They send this to me on January 9th. She then emails me on the 10th after no communication since the 2nd. Not speaking, not even referencing the fact that I've given her court dates. She could have even said, okay, we're going to have the court date on the 22nd or the 28th, because I said I was available on those days. She chose a day that I wasn't available. Like, what? What? Like, okay. So notice, this should have been sent to me back in December. Okay, fine, whatever. It's assigned to a judge. These letters refer to judges, right? What do we see? It's being reassigned. So it's no longer with Terrence Boyle, who would be an impartial judge. It's actually assigned to James Dever. Let me show you why this is the foolery, okay? And this is the point that I'm making. If I can make these searches the way I'm doing, y'all already know how to search your email. You search for anything with my name, Tigress, you getting just that. You're not gonna pull up something to say Jim, because my name is Tigress. Like it's gonna come right up. Okay. So this is the point. I'm doing this in real time. You have it. It's gonna forever be on record because I'm not taking it down. Okay. All right. It's reassigned unilaterally for the continued efficient administration of justice. Let's go out. Let me show you why this dude is a problem. You see all this? Because he's been unilaterally pulling cases over to handle them all, and then dismissing them. You see this? Motion submitted to, he denied all my recent motions. I'm definitely concerned, but I'm going to handle it lawfully. Okay. Where is it? Hold on. Right. Now, these particular actions are for Fair Credit Report Act violations, which are straightforward cases. They're called prima facie when they're straightforward. Like, that means that the defendants have absolutely no argument. Okay. Look at his order. The court denies plaintiff's motions to amend complaint. It was removed by the defendants from state court in Wake County, to the federal jurisdiction. And so I prepared my complaint for state court, which is a different preparation for federal court. Similar, but different, okay? And some of you are aware of the fact that your right to amend your pleading is nearly inviolate, because they are granted liberally, especially if it's your First Amendment. So they removed it from state court to federal, so it was necessary to amend it so that it would be proper for federal court. But he denied it. And then denies it and says, okay, I'm going to grant defendant's motion to dismiss on this basis, because if it's not amended, then it would not be proper, it wouldn't be properly pled for federal court. And then I'm just going to unilaterally dismiss it with prejudice, honey. And the only reason why he does this shall show cause within 14 days as it relates to Blue Stem, because Blue Stem is evidently defunct. And so basically that's his way of like trying to look like he ain't doing anything wrong. There's always that okie doke thing in there. I've learned that over the years. And then he did the same thing with 408. Denies as moot plaintiff's motion to amend complaint. I'll look at this. I don't even understand why he's doing this in part. We'll look at all of it, but I'm appealing it. And then he dismisses my complaint with prejudice. And this right here, that gets me every time too. Declines to exercise supplemental jurisdiction over plaintiff's UCC claim against Spectrum and dismisses it without prejudice. So that alone means that I can refile it. So then, yeah. Anyway, so James Dever is a problem. That's a problem right now. So we're going to see. Because basically and you can't make this shit up, okay? You can't, because the attorney that's spearheading all of this fraud right now, her name is Karen Enlow. Her name is Karen. You can't make it up. I can't make it up. And let me show you. Let me show you how she's with the shits. You can't make it up. Okay, you can't make it up. Where's she at? Hold on, because Karen is with it. Hold on. Yeah, so okay, her first contact with me is back here. Hold on, because she gets a little out of pocket. Trying to find it, but it's 412. So I'm trying to give you as many details as I possibly can. But basically, I'm telling you that Karen Lowe is with the shit. She's the main one that's really spearheading all the nonsense. Okay. All right. So that we have. Thankfully, I didn't get nothing new. This is what I'm talking about when I say I get surprised. They're going to be emails that I don't necessarily. I'm expecting some activity in my case, but I don't necessarily know when certain things are going to be ruled upon, because in the federal jurisdiction, they will rule upon motions before the court without there being a formal in-person or remote hearing. Okay. All right. And some of them are, you know, because it's statutorily appropriate in that regard, but it's not statutorily appropriate as it relates to the gatekeeper. Okay. All right. So now let's jump over to the fraud that I just discovered. So I have argued to the federal court that they are enforcing the gatekeeper order in a way to abuse and deny my constitutional rights, right? Okay, that being said, now let's go to, and this will be the last, because we can wrap this up at 4:30. I don't think I've ever been live this long, and I've definitely I'm ready to eat and sit it down. I think it's raining now. Looks like, yeah, it is. It's raining and it's blah. Okay. But all of this needs to be out because, like I said, I need to fight publicly to protect myself. And please do share this, repost this, like this, all the things. Okay, hold on, I'm losing my train of thought for a second. Hold on. Okay. So I initially filed my injunction in the state court. That was, you know, my way of trying to, you know, how you follow protocol. Like you don't just go to the extreme. You don't go to the CEO right off gate. You kind of go through the manager, then the district manager. You know what I mean? That's basically what I was trying to do. But they were acting like the state court doesn't provide an option for injunction. And of course it does. Injunction can't be permanent, but it would still have the effect of permanence because they need to stop committing fraud. You see what I'm saying? So they tried to argue against my injunction complaint, saying that because she was asking for permanent injunction, then it's not a valid claim. And then of course they were trying to say, of course, then we want to add to this mix. We want to repeat what Meister's been saying, that she's got 172 cases in 72 counties. So this is frivolous. It's not only not a valid action, but she just playing in the courts again. So that's all it is. She just playing in the courts again. So dismiss all this shit. Anything she submit, dismiss it. So that's what they did with that case. Okay. Hold on, let me find it. 188. Or let's go over here. Because this will give this to us. It's already recently in my search, so give it to you right there. Okay. And I'll show you what I mean. I'm just trying to give you a quick summary so it makes sense. All right, you see? State of North Carolina, and you see that it's disposed of, but you're going to see, okay? So it's against all the judges. These are the people that I referred to before, the attorneys who've been in on the fraud. You see it? All the things, okay? This is the case number. See it? George Bell, Lisa Bell, Grimes. This is important right here. Douglas Grimes is an attorney who's been committing fraud as it relates to the last apartment that I lived in at MAA in Mallard Creek, where they had, we discovered after we had been there for 2 months that they had roaches and so it wasn't just water bugs, because they claimed that they were water bugs. That whole notion that they are water bugs to a scientist, y'all stop it. Please stop it. Big ass roaches. So they had the nasty little roaches, the roaches that we associate with lack of sanitation and unfit premises. And then they had the water bugs. And then there was so much disrepair to the apartment that it basically like you could tell that basically what they had done is put Band-Aids on things. And you already know the deal. A lot of us have moved into an apartment that was rigged for us for move-in to give the appearance that the premises were fit. But then we learned after we had been there for a short period that, of course, they weren't. There were issues with plumbing. The plumbing was cracking. It was leaking. The toilets were leaking. There was water damage on the ceilings. It was starting to leak through. It was bad. And so I filed a complaint with the housing code, and they found 23 violations and demanded that they fix the, cure everything. And so that was the start of that. All right. And that's where the particularity of the fraud comes from, in addition to Judge Eagles, who was just appointed by the corrupt new Supreme Court judge that we have, who's in the chief position, which is Paul Newby. That's the Republican. Okay. And yeah, and now you see how the political bullying just continues on. It just continues on. Okay. So basically this is me. All right. So this is all, you see all the filings or whatever. And so I filed my appeals. It says disposed, but this case is not disposed altogether. It's only dismissed against Grimes. Bailey has not responded. Huffman has not, the estate for Huffman has not responded. Effeline Williamson, none of those attorneys have responded. Yeah, so against Grimes, against Woods, who is the attorney for CMS. And the reason why they were included is because they made a copycat gatekeeper order conspired with Lisa Bell. That's how it got to Mecklenburg County. And so they wanted to dispose of my CMS complaint that I just told you about, right? And how else are they're going to do it? Hey, we're going to high five in corruption, because all we got to do to get rid of this is just put the gatekeeper order on her and then act like that's the reason why she hasn't been able to, handle her case. That doesn't make any sense. So if you were actually enforcing the gatekeeper properly, it would work very seamlessly. I would submit my pleading. You would approve it because it is appropriate pleading. It would be filed. I would handle my case. You would review it in a timely manner, approve it in a timely manner. I would file it then in a timely manner. But that's not what's happening. You're denying my rights to due process when you delay approval or review of my pleadings. And that's what they're doing. They're doing it intentionally to make sure that they can dispose of my cases, because they'll say, well, you failed to prosecute your actions. You've heard them say, well, she's had a lot of cases dismissed. You think I'm just not doing anything? Y'all know me to be queen, get her done. How am I not doing anything? That makes no sense. It makes no sense. Look at all the stuff I'm doing. I'm doing quite a bit. But there are the rules, and they are manipulating the rules against me so that they can dispose of my cases. And so now they're attempting to dispose of my appeals because they're mad. Like, we want you to just go away. I'm not going away because you're committing fraud, and I'm deserving of justice, unmitigated justice. All right, so you see my appeal right there. That's the appeal from Grimes. Here's my appeal from Defendant Woods. And then I even asked for sanctions against the state attorney because she lied on court record and said that they weren't served, and they were. And then Judge Eagles came back and said, well, I'm just going to not change anything. Even though I see that what you're saying seems accurate, I'm just not going to change anything. Like, that's not right. She should have been sanctioned, and my case should have moved forward against the state. So that in and of itself was an indication of fraud. Well, Judge Eagles has now proven that her position, her disposition is on the wrong side of justice, and I'll show you why. So basically, there are very specific procedure with regards to an appeal. So you file your appeal, then you have to produce a transcript, and you have time frames with all that. Well, in order to produce a transcript, I have to get a request for the audio video file. This is right here. You see this? And I did this on 11/9 and on the 27th. Where is it? No, hold on, they're up there. So hold on. Request for audio file. I can't see it for looking, but there's one more request for audio file. And it was for the October 26 hearings or whatever. And it might just be one in this action because there's another one in the other action, but I just want to make sure that it's clear. Okay, so I request the audio file. Okay, that was 11/9, and it was timely done because I had asked for the notice of appeal. Then I asked for the motion for relief, and then when the motion for relief was denied, then of course I asked for the hearing. Because you have to produce a transcript, the higher court doesn't have anything to look at if they don't know what happened in the hearing. You see what I'm saying? They don't know, they can't change any decision or consider changing any decision if they don't know what was all discussed. Okay, and argued by both parties. So I didn't receive this audio file until January. Like I got them last week sometime, okay? So this is why I've asked for an extension of time. You see that? This is my extension of time, which is timely filed. I'm like, okay, I'm proactively, seeing that, okay, I still haven't received it in 2 weeks, which is too long. Like it shouldn't take you that long to get me the audio file. So I'm going to need to ask for an extension. So I asked for an extension for each party that's relevant: Woods, Grimes, State. Got it? Okay. Now, this particular case is important. You'll notice that this is the last filing in this case as of 11/22. That's important. And we're going to be able to wrap this up, you'll see, because it goes just that straightforward, okay? And I just had to respond to these. So I repeatedly then asked, let me go over here. Amy Turner is the court staff that I've been in contact with as it relates to my Rule 27C motion. I've been in constant contact with her in that regard. We'll go here. Let's see here. Right here. So this was December 14th. Okay. To Amy Turner. See, Amy Turner. I acknowledge that you do not personally handle my pending motions regarding Rule 27, but having no other court official to whom to address my inquiry, I'm bringing to your attention that my motions have not yet been ruled upon. Do you have any status? Did the judge take them under advisement? I don't know. I've not received any communication. That's why I'm asking. No one responded, so it's unclear to whom I direct my inquiry about the status of those motions. These are not motions that need to be scheduled for hearing. They are normally handled by the clerk. So which motions and for which case? Motions for today's case? No, not for today's case. I'll respond from the feed regarding the pending motions of relevance. Great, just let me know and I'll look for it. And then I say it may be easier to just attach them to this email. There were several motions like this for at least 4 different cases that required immediate attention. And you directed me to forward them to you and advised that you would forward them to the proper court officials to get before the clerk judge for ruling, okay? And as you see, this is my proposed order, which is required. So that's another local procedure, a requirement for e-filing now. If you do not file a proposed order, and proposed order is just what it sounds like. Like, what is the order that you propose? What is it that you suggest that the judge say in response to your motion? What decisions do you propose that be made? Sorry, I had to take some water because I got to get off here in a second for sure. This is my motion, Rule 27. Got it? So then she says, yes, I recall this. This is all on the 14th. Okay, thank you. So she'll follow with the clerk. Okay, thank you. Also, please advise who was the clerk judicial assistant in that case today, because she was acting a fool. Ebony never responded. Ebony kept evidently muting me, and I wasn't even talking. Like at one point, the judge was addressing me, and I would unmute myself in preparation to respond to him, and she would mute me. And it kept going on. And in fact, it's on court record. Like, I'll show it once I get that audio file, because now that they record the video and the audio, so it'll show what I'm telling you. So it was very rude for her to do that, and very, very highly inappropriate. She should not be working for the court. And I feel that she was doing that prejudicially. You know what I mean? That gives me the impression that they've been talking about me. You see what I'm saying? Behind the scenes, and it's like somebody like, treat her badly, because that's what we're doing. High five, that type of BS. All right, so I then send to Amy. Just like I said, I'll do it in a separate email so it's more clear, right? So this is for this case. This is the MAA. This is the apartment complex for which Grimes is the attorney that I was talking about, okay? So I asked her, hey, here it is for the case above reference. I do not see an order. See attached printout of case activity. We're going to go to the case activity real quick. I believe this was as of January 5th. Yep. Okay. So as of January 5th, Asa, a little bit quieter. As of January 5th, you'll see that the only thing on this case record for Mid-America Apartments, hence MAA, right? And we'll show you again. Here's Eagles. Eagles all in the mix. So it's not merely coincidental that Paul Newby just gave her a promotion. I'm trying to show you where Grimes is. Should show. It may not show his name, but Grimes is the it should show. That would be. Hold on. It's normally in here because it'll tell the parties to be served normally. Hold on. Let me see if I can find it up at the top. Yeah, there we go. Right here. So these are the parties. I'm the plaintiff, defendant. Okay. Mid-America Apartments, James Douglas Grimes. Got it? So he's not just random, like they will try to, have you all to believe. The people that I'm suing, it's very specifically so. It's not random. Nothing's random about it. Okay. So then you have the 27 motion, right? So nobody's answered my motion since 11/27. I only have like so much time to produce this transcript to the Court of Appeals. So I said, okay, well, friends, then I'm going to have to, we'll go to it. I'm going to have to let the Court of Appeals know what's going on, and I'm going to have to renew my request for more time through the Court of Appeals if y'all not going to be doing the right thing. So that's what I did. Here it is, McDaniel versus MAA. Let's go look at the document. And I did the same thing for the case, the injunction case against the state. See this? Mid-American Apartments. That's me. That's the same case number. Now comes plaintiff. Having first moved the state tribunal for an extension of time, and having no ruling today, to hereby move this court for additional time to produce and deliver the transcript, and to file the record on appeal, to file briefs to preserve my right. I pointed out on October 27th, I did this. On November 9th, this is what happened. I requested the audio copy of the hearing, didn't receive it till January 2nd. Regarding the time, I'm going to need an extension because I don't have what I need. Today, despite my innumerable inquiries and communication, the court purporting to properly handle my motion, it remains unaddressed. And the appeals court can't give you an extension in time unless you have first asked the state court for that extension. Okay. All right. So I filed that for that case and for and that's the other one. and for, there you go. The one against Defendant Woods, I did them all. Defendant Woods, Defendant Grimes, they're all there, and the state. See that? You even saw it right there too. McDaniel versus state, you see that? And then it says McDaniels versus state right there. And then this one I think is against Woods. No, I mean Grimes, right? So Grimes, Woods, state, okay? So now you see them, all right. Fast forward, the Court of Appeals gives me an order on all the cases. It says, hey, the motion filed in this cause on January 11th and designated as this is dismissed without prejudice for the refiling to show that I filed my notice of appeal, showing that the plaintiff filed a motion with the trial court seeking an extension of time, and showing that the trial court has not ruled upon my extension. It's pretty straightforward. This is the gray star because there were 3 actions. So this is the one for the state. You see that? Same. He's asking for the same thing. This is Ed Eugene Soar, the clerk of North Carolina Court of Appeals. He's asking for all this and this, right? Same thing. Okay, so then remember, there's nothing on file yet that shows that there's been an order. So then I respond to all these things. Okay. And this is what I discover. And this is a demonstrable occurrence of fraud. All right, so here I am. I attach all the documents they're looking for. And I say, plaintiff also brings to this court's attention, this is against the state, that as of yesterday, January 10th, of course, when I looked and I presented my motion to them, there was no order on my motion for extension. Okay. And as of today, which was yesterday when I filed this at 6:04, there still was no order. Okay, now why is this important? I'll show you why it's important. The reason why it's important is because when I look, because remember, I'm looking at all these cases. This is Mid-America Apartments, right? And let's go to this. And then 23 CV. This is the Mid-America Apartments. Sheesh. See that? Mid-America Apartments. Well, what'd you know? Look at this. What'd you know? How convenient. January 9th, all of a sudden, there is an entry by who? None other than Judge Eagles. And what do you think she's doing on the 9th? Showing the 9th. Now, I went into the system on the 10th. Order granting plaintiff's motion for extension of time. But see, this is where she played herself, because there were 3 cases that I had filed the same motion for extension of time. And let's go back to it. So the other one appears on the 9th as well. Pull that up. I think this is it. It's either one of these we're going to see here in a second with the gray star. So she did a good job with her fraud, but that's how fraud works. She made stupid mistakes, so that's not it. That's credit management. it's disposed because that credit management is Spectrum. That's the one in the federal court that was removed to federal court. And you can look it up and look at the case file and see that some of y'all like, we already know. We know we trust you. We got you. Okay, so I'm trying to pull up that one. Just hold on. And then this ends it. I'm proud of myself for even. This also was, I'm trying to think. No, this is still pending. Hold on. I may have to just pull it up this way. Maybe it'll be easier. It's the gray star one. That's what we're trying to do. I don't know. Yeah, I don't think I have. Hold on. Trying to do it in a faster way. Let's hope that's it. Because I mean, it just recently did them, so let's hope. No, this is the one that I consolidated effectually. All right, we're gonna do it this way because this will be, oh God, hold on. Let's see if we can find gray star. There we go. I just need the case number so I can pull it up. 8472. That's all we're doing. Just do it faster. Okay. Cars, so we can go and get offline. And I can rest. Look at the time frame. That's good. 4:40. All right. Look at there. Look how convenient. Ooh, and she did them right after that, one after the other. If you recall, the other one was 11:54. Or yeah, one. You see what I'm saying? This one was 11. I misspoke, but they're one after the other. 11. So she did that one at 11:55, and this one at 11:57. But see, she played herself. See, I had already looked at this on the 10th, and I wish that I had gotten a copy because I normally take a printout of the case record every time I go into it, just so I know what was in the file as of that time and date. You see what I'm saying? So where she messed up is to perfect her fraud, she should have also put in one for which one? The one against the state. But that's where she messed up. Crosswalks. She messed up. Because see, they were all filed on the same day. Because I did it all at the same time. All of my motions were filed on November 22nd. See that? 22nd. All of them. She messed up. She didn't put in the order granting my extension of time in this action. So she fabricated a record that she had actually put the order on file so that she looked like she had done nothing wrong. And so that means that the Court of Appeals is hipping her to anything I file behind the scenes. And that is unlawful because it should just be fairly processed. It shouldn't be this backroom talk. Right? Okay. And so that's what I let them know. Hold on. Let's go to it. I think I was in it. This backroom talk is unlawful. Let's see where we're at. Is there? Here we go. Okay. So basically, I go into great detail, and here we are. Hold on. That's Mid-America. Hold on. Let's go back. And 24 is, I think it is. Let's make sure. Yeah, okay. This is the one, right? That is the case number, state of North Carolina. And I basically say she has played herself because it wasn't there. There was no order. And my document is the last one on record. And so then I go into further detail and I say, on January 11, 2024, however, when accessing the case record to obtain the documentation requested by the court to reconsider her Rule 3 motion, plaintiff discovered that there was an order there all of a sudden, filed purportedly with an entry and filing date of the day before, despite such not being on record January 10th. Accordingly, plaintiff reasserts that her claims on judicial misconduct, public corruption, gross and malicious pattern and practice of gross violations of her constitutionally inviolate rights to due process, albeit substantive and or procedural, and bad faith enforcement of the gatekeeper order at issue, are indefensibly, demonstrably factual as alleged. Because it's clearly evident that the Wake County officials, Eagles, were privately informed about plaintiff's January 10th renewed motion, and then fabricated a record that it had timely and properly entered an order on her grossly delayed motion and adjudication thereupon from its original filing on the 22nd. Like, you're trying to play in my face. You're literally trying to play in my face. I go into, great detail. There's great detail there. And hold on, because there's one of them where I go into a little more detail. Hold on, let me see if I can pull it up. Let's see. I think it's in this one. We're going to see real quick. And then we're out of here, y'all. I can't believe I'm telling you, I'm going to lay down. But yeah, I pretty much said that just trying to make sure because I go into a little more detail on one of them. So it's well known. Yeah, here it is. Okay. So you'll notice that pretty much all of these responses are identical because the same issue applies. Like, it wasn't there. My motion was the last one, right? That's the last thing on case record as it reads. Further, plaintiff also brings to the court's attention that on yesterday, January 10th, regarding another impending action for which plaintiff is also a pro se complainant, and notably concerning her identical Rule 27 motion, but with specificity for that action, no order on my motion had yet been entered on record in the case, and accordingly did not show in the system on January 10th when I filed my renewed Rule 3.1 motion with the Court of Appeals. And of course, that was therefore the reason for me renewing my motion. Why would I renew my motion on January 10th if there was already an order in the case record? On January 11th, however, when accessing the case record, ta-da! Her magical fraud Eagles Magical Fraud, January 9th, there's an order in there. But see, she played herself. She messed up because she didn't put this same order. She didn't respond to my Rule 27 motion in this case. And I made sure intentionally to do it for defendant Grimes in this particular action because they both are definitely co-conspirators. Ooh. So y'all, honey boo boo. Yeah. And so, whereas, because we already know that it will be brought up against me that, you know, okay, well, you were online. We figured out that you were online. Honey, I'm not doing anything unlawful. I sure am. I'm online. I told you I was not available on the 19th. I'm not available on the 19th. I gave you my available dates. I'm not available on the 17th because I'm literally appearing before the North Carolina bar on that day. I'm not available on the 19th. Because of not only the PhD program, like right now we've been going back and forth on the date that's being scheduled for my application process, the review. So I'm not available on the 19th. So it doesn't matter if I can sit through the court session and just stick it out, you know, just tough it through. I'm not available on those days. And I gave her the dates that I was available. So, yeah. Their shit has hit the fan. And it's like diarrhea level shit. It's like baby explode diaper type of shit. Y'all have a wonderful Friday. We are appropriately ending at 4:04 and 55 seconds. Those numbers are very highly appropriate for this. And I will update you as I learn more, but I am now going to get it together and not get it together at the same time and go in here and rest. So if you ever thought that somehow my life was perfect, or if you ever thought that somehow their fraud was not that big of a deal, like, oh, it's not that big of a deal. You're a politician, so you're dealing with, you know, you should expect there to be, you know, backbiting. This is not backbiting. This is not just somebody spreading a rumor, you know, some little childish rumor. This is criminal conspiracy and public corruption. I am Tiger Sydney Acute McDaniel. This has been a long ass session of the Evolve Weekly, The Ethical Gatekeeper. Have a wonderful weekend.